Good afternoon all. This hearing is in the matter of CFI 009-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Holman Fenwick Willen. Lead counsel is Mr. Albert Sampson. The defendants are represented by Jones Day. Lead counsel is Mr. Carmine Conte and Mrs. Chloe Bell. Thank you, Your Honour.
Thank you very much. Yes, Mr. Sampson.
Your Honour, good morning. Thank you. This is the disclosure hearing listed pursuant to paragraph 7 of the order that you made at the last CMC. I know I've done the introductions, but they don't appear on the transcript. So I'm here for the claimants, and Mr. Conte and Ms. Bell are here for the defendants today. Your Honour, you ought to have received a hearing bundle, which was filed by HFW on Friday, skeleton arguments and draft orders from each side on Monday. Can I just check that those made their way to you and that you've had the chance to do some pre-reading?
Yes, I've read the skeletons. I've looked at the witness statement, and I have looked briefly, but not in any detail really, at the search terms.
I'm grateful for that indication, Your Honour. That's fine. We can pick things up as necessary as we go. I understand, by way of housekeeping, that the court is able to afford us the time that's needed today, subject to the court's staff's availability. Is that correct?
Yes. What are you anticipating, Mr. Sampson? That sounds ominous.
No, I'd hoped that we'd be able to do this in the half day that was originally allocated, but I was told that more time is available if required.
Yes, I can do whatever's necessary today. So we really do have to try and get this sorted out one way or the other to make sure things move on.
Apologies, my lord, and I hate to interrupt. It's just in terms of the room booking that I've made. What's the maximum time, so I know that we have the facility to be here and I don't need to extend the booking? What's the ultimate deadline, as it were?
Well, I think you should certainly work on the basis that we ought not to be keeping the court staff late. It's now what in Dubai? It's midday in Dubai now, and I really do think 5 o'clock Dubai time is about as late as we ought to be keeping the staff. Does that sound feasible, Mr. Sampson? I mean, I really do want to try and get things sorted out today as far as possible. So from my perspective, there's no difficulty in my sitting through the afternoon in the UK time, but that would not be satisfactory for those in Dubai.
I agree, Your Honour, and I think we should be done certainly by 1 p.m, but I hope earlier.
Right. Thank you. Thank you, my lord.
Is that right, Mr. Conte? You can cope with that?
I can cope with that, and luckily I won't be thrown out before the end of that time because the booking will cover me until that time. So I appreciate it, my lord.
Okay.
Excellent. Well, Your Honour, let's get to it. The agenda is on the first page of my skeleton argument. I'm afraid to say that in some respects the agenda is not quite agreed, but the running order is, and I think that the parties will address you on the items on all of the items they've been dealt with in the skeleton arguments. So although it was not possible to fully agree the agenda, I think we're all proceeding on the basis that this is it. So if I may, I'll start with progress in the disclosure review. And I know in the past the way that these hearings have run is that the parties address you on each of the agenda items sequentially. I'll take my cue from you when we get to the second agenda item, Your Honour.
Well, to be frank, Mr. Sampson, I'm not terribly interested in history, nor in delays. I'm only interested in where we are today and where we need to get to.
I understand that, Your Honour. Well, I mean, where we are today is in some respects related to the history. I don't want to sort of rake over it in great detail. I mean, the position that we're in as of today is that the claimants have, as they did at the time of the last CMC, the data that's referred to in the electronic disclosure questionnaire uploaded and ready for review. So over the last month, we've sort of been ready to get on with the exercise, and the hold up at the moment is the keywords, which are not agreed. And the reason we say that they're not agreed is because the parties haven't been able to, the parties have met twice, and the parties haven't been able to agree the keywords in the course of the 2 meetings, which have come after an exchange of keywords on the papers. And we say that that's really down to the fact that the defendants started their exercise after the 2nd of October in terms of collecting the data, uploading it, processing it, and putting it in a state where they could search it and interrogate the way that the keywords would operate against their reviewable population. Now, the claimants were in the position to do that by and large before the first disclosure meeting, but the defendants by that point had only managed to provide us metrics on 1 keyword, which is Dubai, in respect of 5 custodians out of their 31 custodians. And so at the first meeting, we could only really have a general discussion in the abstract, because obviously points were taken about keywords looking like they may be disproportionate, but we said that that really needed to be tested by reference to the data, and given that the parties were proposing to run a relatively sophisticated disclosure exercise, that ought to be done. And we had flagged that in our letter of the 25th of September. Then on the 21st of October, the parties were able to exchange their metrics. So the claimants provided data in respect of all of the searches that were being proposed for their custodians on either side, and the defendants provided metrics in respect of 15 custodians, so the searches for 15 custodians. So that gave us an indication of the landscape on the keywords, and we were able to have a discussion that was a bit more focused on specific keywords and how they had been constructed. But the issue was that we came to that meeting prepared to get down to brass tacks and try to agree some specifics. And our impression was that the defendants didn't really want to do that. Now, that's been set out in the evidence of Mr. Braganza. But I mean, I do want to highlight a couple of points in relation to that, because they're actually live today. So one proposal that we made in the course of that meeting on the 24th of October was that the parties should simply agree searches that generated fewer than 1,000 hits. Now, that is, in substance, the floor proposal that my learned friend set out in his draft order, and which I presume he'll be pursuing today. But on the 24th of October, the defendants were not prepared to agree that. They wanted to go away and come back to us with their proposed number. And we haven't seen anything on that in correspondence. We now have the proposal for a floor in the draft order, but there's no number attached to that. The proposal is that the parties should go away and agree what the floor is. And Your Honour will have also seen that there's a proposal to agree a ceiling. Anyway, so we say that that's territory that's already been covered, and the parties haven't successfully managed to agree that. The second point was that the defendants advanced the position that it was difficult to second guess the language that parties used at the time, and so search terms ought to be more expansive. The claimant's response to that was, well, let's just agree to put all of the terms in and then work out how we might exclude irrelevant material. So sort of do it the other way around. And the defendants didn't want to agree to that on the day either. Their position was that suggestion only applied to specific topics that were of particular importance to the parties. The only one that they identified in the meeting was the changes to the credit policy in the fourth defendant, which were imposed on the business of the first claimant, and which led in part, they say, to the disagreement between Mr. Walia and BJSS. We then sort of try to engage with the criticism that some of our searches...
I'm not following that, Mr. Sampson. The point being that it was... were there keywords that were agreed in relation to the credit terms issue or not?
There were agreed key terms in relation to the credit issue. Right. That was identified as an important topic. So yes. The point that I'm making is that the approach, in principle, that was being suggested was one of expansiveness.
Yes,
but not so expansive that the parties should simply agree everything that they were proposing and then sort of approach it from a different angle by trying to exclude irrelevant material. You know, that was the claimant's suggestion, just to sort of cut through the discussion and just find find a different way of approaching the list. So then we had to have a discussion about overbroad search terms. And again, we made a proposal in relation to a specific term. We set it out in writing after the meeting. We haven't heard back, but we think that that's the sort of we thought that was the sort of thing that the defendants would be wanting to hear from us. Not only is it a matter of principle, should you try and come up with more restricted keywords, it was a proposal to try and agree a specific term to use. Then the other sort of approach that we took was to say, well, why don't we agree the search is proposed for some of the smaller custodians? So Enid Yip is a person who was in charge of the hiring exercise that the fifth defendant ran in respect of the Bank of Singapore relationship managers. That's how it got its private banking business up off the ground.
Yeah.
And in respect of Miss Yip, all of the keywords, which are quite few in number, produce fewer than 500 hits, save for one, which is transfer, which is 902 hits. Now that was intended to be a pragmatic solution. You'll note, Your Honour, that 902 figure is below the floor that we had suggested. Now the defendants said that they weren't likely to agree to a custodian by custodian approach. They sort of wanted to agree points of principle and deal with the list in the round. So, Your Honour, we sort of tried various approaches in that meeting and we didn't agree anything. And the upshot is that as of today, the keywords list is not agreed. It does contain terms that have been described as agreed so far. And the way that operates is that Jones Day helpfully produced a color-coded version, and things that were to be treated as common ground were put in black text. But the parties have exchanged this list on a sort of subject to instructions basis. So the agreement in respect of it has always been provisional. But I will come back to how we sort of try and work with what has been agreed when I address you.
Well, what are you going to ask me to do, Mr. Sampson? Are we going to look at a 59-page list and red, yellow, and black, and ask me to work through it?
No, Your Honour. I think the common ground between the parties today is that list is unworkable. We've been discussing it for a long time, since September, which is when the claimants provided their written comments on it, and we've met twice to talk about it, and we've got nowhere because the issues haven't narrowed, and the agreed terms are as they were when Jones Day produced the consolidated colour-coded list on the 7th of October, so before the meetings. The meetings have not resulted in a single search term being agreed. I think
I'm sorry to cut you short, Mr. Sampson. I'm just trying to find out, in a sense, where we're going and
Yes.
what it is that you're going to ask me to do, and then I can ask Mr. Conti what he thinks he wants me to do.
Well, indeed. So we left the 24th.
Apologies for interrupting, but I thought that keywords came forth. I thought that the first item on the agenda was where we are. So I have a few things that I would like to make submissions on before we get to this.
Well, all right, but as I say, I'm not really very interested in the history. I want to know where we are and what has to be done to move this forward. And, if I have to sit here and for hours on end and work through keywords, I'll do that. If I have to do that in the privacy of my own study, again, I'll do that if it's absolutely necessary. I regard it as a slightly inefficient process because the parties know much more than I do. And also know much more about how these processes work in practice. Being of the age that I am and the background I come from, when I was at the bar, disclosure did not take place in this manner. So my experience of it is limited to that as a judge and an arbitrator. So anyway, what I want to know, essentially, Mr. Sampson, if you can put it in a couple of sentences, is what you're asking me to do today. And then I can ask Mr. Conti what he thinks I should be doing today to see if we at least have some common ground there.
Thank you, Your Honour. I've tried to sort of cut through my proposed speechifying by getting to the issue. What we have proposed is a set of keyword lists which are based on what the parties had been discussing up to this point, but which have been reduced in their scope in a variety of ways, and the principal ways that we've done that is to group custodians together where possible, because previously they were being discussed mostly on an individual basis, to reduce the number of keywords being proposed in respect of each group, to reduce, where possible, the scope of the keywords, whilst still ensuring that all the issues in the case are adequately and fairly covered, and also, where possible, while using keywords that were agreed between the parties previously. And those lists are set out in the annexes to my skeleton argument. They were sent to Jones Day on Monday, shortly before skeleton arguments were due. So my learned friend did not have the opportunity to address them in his skeleton, and obviously has only had them since Monday. I stress this wasn't some sort of ambush tactic. We had the second meeting on the 24th of October.
Yeah.
We saw how things were going. We went back to the list. We tried to work out how we could streamline it and rationalize it. But then we also needed Ankura, our e-disclosure provider, to actually run the terms and see what hits they generate. And Your Honour will have seen that in the time available, we haven't been able to run the search terms across the full population of custodians. We've had to sort of do a sampling exercise. I will come on to all of that in more detail. I want to show Your Honour why we say that it's a reasonable and fair list, and why we think it will have the effect of reducing the number of documents that the parties will have to review in conjunction with other points that are up for discussion today. But the proposal is that you simply approve those lists and allow the parties to get on with the review. Because if we have, I mean, the position today, I should sort of cut this bit, but I started out by saying that the claimants have got their documents up on the platform and are ready to search.
Yeah.
The defendants are getting to that point, I think.
Yeah,
around,
shortly, they say. Yeah.
Yes, exactly. So
next couple of days or so.
Precisely. So if we can settle the list, then everybody can start reviewing the documents and we can just get on with it. And the ultimate aim here is to hit the deadline of the 31st of December. And Your Honour should approach the hearing today on the basis that that is the deadline. There is no application to vary the deadline. And we are now at a point where every day is important. Every day, a day lost will make it harder to meet the deadline. So the parties should just get on with it. So our proposal is that you approve our lists. Mr.
Can I
Conte,
stop you again? Can I stop you again, Mr. Sampson? When you say approve the list, this would be the list that the parties then go and run the search terms to see what number of hits they get, because we haven't got to the stage of actually working out whether there then need to be further exclusion terms or anything else. I mean, in a sense, one's got to start somewhere with all this stuff. And I know you're saying, well, we've had 2 goes at meetings and haven't even begun to start, really. But there is a question of simply getting the thing off the ground, isn't there? So that's my first question. The second is, when you said group custodians, I understand, reduce number of keywords, I understand. When you say reduce the scope of the search, what did you mean by that?
So to deal with the first question, Your Honour, the proposal is that the keywords are approved for use, for searching and for review. They're not approved for the purpose of running the metrics and then having a further discussion. We say that today, Your Honour should just order those are the keywords that the parties will use, and they will proceed with the review. That is, of course, there is always potential refinement along the way, and the parties may find ways of further limiting the volume of documents to be reviewed. But frankly, the only way of working that out is by actually getting started and looking at some documents. And because of the limited time, the parties should get on with it. And the metrics question was obviously important to the claimants, because we wanted to use that information for the purposes of the discussions. The parties exchanged what they could in the time that was available. They had the discussion, and it has led nowhere. So we say that it's really sort of grasped the nettle time. And if Your Honour is satisfied that what the claimants are proposing will give rise to a reasonable search in conjunction with the other techniques that we're going to discuss for reviewing the population of documents, then we say that Your Honour should just order that as the approved list of keywords, and the parties can then work out any issues if they encounter any along the way. So that's
So the effect would be that I order these as, quote, the keywords, and if the number of hits proves to be so enormous that the parties agree that that just isn't workable, it will simply then be for the parties to agree some further refinement, excluding terms or whatever. Is that what you're saying?
that's broadly it, Your Honour.
Yeah.
I think we can try to agree some refinements. I mean, I would hope, obviously, agreement has been a difficult topic, not just for the keywords, but as Your Honour knows, draft orders and hearing agendas. The parties are just not good at agreeing things in this case. But if we have the bulk of it sort of set by the court, then one would hope that we can make refinements along the way. And that is, in fact, part of the technology assisted review process, is to perform quality control checks.
Yes.
And so if those show that the keywords are in some respects not really working, then the parties can sort of look at the data then and come up with something between themselves. But we have a deadline, we need to get to it. And so our proposal is all about just getting started. Does that deal with the first question, Your Honour? And the second,
yes, no, I understand. Yes, thank you.
The second point was what I mean by reducing the scope of the keywords, and that's really I will give some illustrations when we come on to that agenda item, but previously we had things like transfer, because this case is all about a transfer of business. Now, obviously, the fourth defendant is a financial services, well, it's a bank, and the fifth defendant is a financial services business. Transfer is a word that does come up commonly. And so we've had to find ways of capturing the essence of transfer, but making sure that we're not capturing irrelevant documents. And so the way that we propose to do that is to add further words to a search string. So you then have a search inquiry that has multiple criteria that a document will have to respond to be caught.
Yeah, so it's and or whatever the appropriate, I've forgotten what the word is, joining word of whatever it kind is. It's
the techie people call them Boolean operators.
That's the one.
So we have Boolean operators, my lord. So that's what I meant by reducing the scope. Now, that's our proposal. I'm sure that you want to hear from Mr. Conter and the defendant's proposal. I mean, we say that what they're proposing is a recipe for missing the deadline, because it involves the parties going away, discussing the keywords, trying to agree, and then if they haven't agreed, or I should say when they haven't agreed, coming back to court in sort of around 2 weeks' time to argue over the same ground. But
okay, understood. Well, let me hear what Mr. Conte thinks of that.
Thank you, my lord. I'm not sure where we are, whether we're in issue 1 or issue 4 now. I was told that we would be sticking rigorously to the agenda, but can I make some general response?
The judge always takes you out of your order, whatever you expect. So there we are. As I'm trying to get a handle on exactly what it is that each party wants me to do at the end of the day. Well, I understand what Mr. Sampson's telling me he wants. Where do you hope to get to at the end of today?
Well, my lord, it's this at a very high level. The parties had sought to agree keywords based on particular suggestions by both sides. When the evidence went in, it still wasn't clear what the agenda item was, and there was a vague reference to the claimants wanting to settle the list. Therefore, we had prepared for this hearing on the basis that what we would be discussing is the lists the parties had discussed at the meetings. 30 minutes before skeletons were due, an entirely new proposal was sent to my instructors in correspondence. We asked for clarification about how that had changed the previous landscape. That wasn't provided. Then my learned friend and his skeleton provided annexes of some length with a completely new approach. And so when my learned friend says the intention wasn't for litigation by ambush, I'm afraid even if that wasn't the intention, that was the result. And so when my learned friend says today, well, he'd like the court to approve the claimants' lists, that's a unilateral list. We haven't had the time to go through it. We haven't had the time to consider it. It does contain completely new search terms. It radically changes the approach in terms of grouping. And it's a list that would take time for the defendants to consider. And so although in principle, if in the claimant's evidence, they had said, this is our approach, and we'll be sending you a new proposal in a day or two, and please let it be known this is what we want at the hearing, I would be making a very different submission. But my submission to you today is, because of the way that the claimants have conducted themselves, regrettably, it's a binary option for my lord, in the sense that it's either approve the claimant's key words that I cannot address in detail because I haven't had the time, or it's instill another regime to let the parties go away, have an informed discussion. And so if we do have another hearing to try and sort out any disputes, you can have some informed views from my clients about what they say the term should be, and you can make a choice. Now, going back to what my learned friend said about the hearings, it's very disappointing that he says what he says and he makes the submissions he makes about those hearings. In Mr. Braganza's witness statement, he takes issues with certain things that happened at those hearings, and most of them, I'm afraid, were my comments. And so I don't like giving evidence from the bar table, but I will be very clear. I have a very different recollection of what happened at those meetings, and I've set that position out in the skeleton. There was much made in correspondence about those meetings not being adversarial, so I was very disappointed to see Mr. Braganza talk of concessions and change of positions and of backtracking in his evidence, because that certainly wasn't my recollection, and it's not the way we approached the hearing. Now, yes, there wasn't a lot of agreement at the keywords hearing, but that was for very good reasons. The defendants weren't able to interrogate their data, and that wasn't news to the claimants. We told them that the data wasn't in a format that was easily searchable, so they knew this. We tried to make as much progress as we could. Now, my learned friend says, well, in my new proposals that, as I say, I haven't had time to consider, they talk about a flaw. Well, the flaw was suggested by the defendants in that meeting. And when he says, well, they wouldn't even agree to Ms. Yip's terms, and they were low. All but one search was below, only one search was 900 keywords. What he hasn't mentioned is my response when the proposal was to agree Miss Enid was, I said, well, that's a decent proposal, but how about we take it one step further, because that's one custodian. Why don't we consider a flaw? So rather than doing this custodian by custodian, we consider a flaw which will clear away the terrain, which is what's in our draft order. I said, so I can understand that on a broad basis. If you're telling me Miss Yip is very important to your case theory, and therefore that's why you want her included, I can also understand that. But the answer is no, she should just be included by reasons of pragmatism. But I like my pragmatism principled, and I want it to have maximum utility. And so it would make more sense to agree to a flaw, and it would make more sense to take an approach across the custodian base. And so I know this is an issue for later on, but in short, my submissions will be that it is not the correct way forward to just approve the claimant search terms, especially in circumstances where we haven't reviewed them and we can't comment on them. There's much utility in the parties going away and engaging. And in my proposals, I had suggested an exchange, a very short and truncated period where the parties exchanged further lists. And I had suggested the defendants go first. Now, my learned friend has done the work and effectively taken the first go and sent over his proposals. So short point is defendants would be in a position to send over a response on Monday, a short exchange of proposals, and then a very, very narrow hearing if there is anything to be discussed.
Right, well, let me just look at that for a minute. I'm looking at your draft order.
Yes, my lord.
What was your paragraphs 3, 4, and 5? You're now suggesting be rejigged on the basis the claimants have sent their list, and you can respond by Monday, which is, what is that, the
11th, I think, my lord.
Oh, that is the 11th. Okay.
Yes.
And then what happens after that? The point is very simple, isn't it? At the end of the day, Mr. Conti, we have to make progress on this, and we have to aim for the 31st of December, whatever the practicalities may ultimately turn out to be. And what I need to order today is something that is going to achieve that. And if I have to have further hearings, well, I have to have further hearings.
And we would absolutely sign up to that, my lord.
So what you're suggesting is that by 5 p.m. on the 11th of November, you review the claimants list and respond, right?
Yes, and can I say the reason why that's important The defendant's main objections to the claimant's terms are based on proportionality. So they're not based on other potential objections. What essentially it boils down to is, if you have a very large universe of documents where we need to go away and review hundreds of thousands of documents, there will be no hope of us meeting the deadline. And so even if there is a little bit more time in this stage, if it results in a 50,000 document universe rather than 200,000, you will have minimized the review process by weeks, if not months. So the point is, it's all well and good for my learned friend to say, well, let's just settle something today and get on with it. But that's all run by the figures. And so why the 11th is important is, we will have the data, hopefully all of the data, uploaded to Relativity. We can run searches by that point. We can give my learned friend data and metrics to say, here's why your suggestions work, or here's why they don't work. Here's what our totals are. This is our floor. This is why we say the floor should be X, because when you add all of the floor entries up, here's the number of documents we have to review. We can do this by a process of mathematics and by a very data-driven approach, which is what you need to do when you're in the realm of proportionality, because that directly feeds into how long it will take us to review the documents. Now, on the review, it's in the evidence. We say that a reviewer can get through about 1,000 pages a day. So we've got to be realistic about what, and that's just first tier. It's not second tier, not review. My learned friend says, it was unclear in Mr. Braganza's statement, but now he says they can do effectively 500 documents a day. We've assumed about 5 pages per document, which means it would be 2,500 pages that their reviewers will be doing a day. Frankly, in my submission, that's unrealistic. No one can get through 2,500 pages.
Well, that all depends how big the document is. As you say, if you've got a one sentence email, that's one thing. If you've got an attachment that is 6 pages long, it's another. And, you know, one's only guessing at this stage.
Absolutely. But my point being that the speed of the review, we say realistically, is about 1,000 pages a day per reviewer. Okay. And so the answer cannot be, let's have an enormous amount of keywords and speed up the review by forcing a reviewer to get through 2,500 pages a day, we say. So the point being that, yes, in my proposal, we may end up, the parties may agree. They may finally agree something in this case. But if not, let's say the parties can't agree, my proposal is, let's set a floor to clear away some terrain. Let's set a ceiling to make sure that no one entry goes above a certain amount, to make sure that we keep this under control from a proportionality perspective. Let's have some exclusionary terms applied to exclude the irrelevant data, which has many benefits that I'll take my lord through. And then let's have a discussion on what remains. And then if there's a narrow range of disputes, then we can have however many pages we need, which will hopefully not be, first, they shouldn't be 55. And secondly, you should have competing proposals. My concern about moving today on is I just don't have a position for you on what we say on the entries in the new world that my learned friend has proposed.
Well, I understand all of that. Let's work on the assumption that you will have all the data uploaded by the end of this week.
Yes. If that's the case, then we're happy to sign up to what is, I appreciate, an aggressive timetable. Exchange on the 11th, 13th and 15th. There will be a lot of metrics to go through in the exchange, but we are committed to pushing through this as quickly as possible. And the timetable ends up with the claimants confirming on the 18th, which is next Monday, whether they agree to our last proposal or not. And then if they don't agree, we exchange skeletons 2 days later and it's pistols at dawn.
Well, I understand all of that, but since the claimants have already produced a list, and you could respond, you say, on the 11th, we can cut out some stages in that. But my real question is, if we go down that road, when are you going to be in a position, realistically again, when ought agreement to have been reached between the parties on the basis of the floor, ceiling, metrics and so on? And is the suggestion that exclusionary terms will be agreed at this stage of the process or later?
Sorry, can I take some instructions, my lord, for one moment?
Yeah, what I want is a clear idea of dates. all right, on you as to what you propose, and then when this matter would come back before the court in the absence of any agreement. So date by which agreement ought to be reached, and exactly on what it is you say would be agreed by that date, and then when this matter would come back before the court for the court to have to make a decision on such matters as are not agreed. Obviously, the later we go into November, the less likelihood there is of anything being completed by the 31st of December.
I appreciate. May I take some instructions for one moment?
You may.
Please?
Yes, yes, of course.
My lord, thank you for giving me the time to confer, and apologies that that took a few minutes.
No. If it helps to advance matters, that's all good.
It's very, very kind of you. I thank you. So we've devised a timetable, but I just have one caveat to the timetable because I want to ensure my lord has his point. There are various different types of documents in play. There's electronic documents, then there's hard copy documents, and there's anonymous materials. This regime only applies to custodial electronic documents. So whatever we decide here, just to be clear, I don't think it's proposed that this is going to include the hard copy documents. And I don't think it could, because from a letter I received, or my instructors received late last night, the other side have about 135 boxes that they haven't started reviewing yet of hard copy documents. And so I don't think, unless my learned friend submits otherwise, that this regime will apply to hard copy documents. And so, although we're more than happy to sign up to the timetable I'm about to mention, the reality is this will not include hard copy documents. We're very far along in that process, and I can update my lord as to where we are. But my understanding is, from the correspondence received last night, is that the liquidator has not started reviewing the 130 odd boxes of hard copy documents that they have to review. So I just know that. So,
well, I thought there were also issues on your hard copy documents, as I read the evidence, that you hadn't got very far with those. Am I wrong?
We have made significant progress on, I think, for the D4, the D5 side rather. We've made significant progress. It's done, I'm told. It's actually done, scanned, processed, uploaded. Sorry, it's
Scanned. It's being uploaded.
Sorry, scanned and processed and being uploaded. Apologies, it's being uploaded. So significant process on D5, and D4 we're moving as fast as we can, but we anticipate the volume will be low, so we don't anticipate that should hold things up very much. Now, in terms of the proposal sorry, one moment. Sorry, one moment, my lord. I seem to be having. Sorry, apologies, my lord. I seem to be having a slight technical issue. Okay, so in terms of the proposal for the timetable moving forward, what we say is we could respond by the 11th, including in that response our views as to what the floor and the ceiling should be. As we will be able to run the metrics, that response would contain all of the relevant metrics for each of the suggestions that we say we make, and in response to the claimant's suggestions. The 13th, being 2 days later, the claimants could either confirm that they agree with our proposals or put forward a counter proposal. By say the end of the next day, we could confirm whether we agree or not. We could do skeletons by the end of the day after, which is the 15th, with a view to having a hearing early in the following week. And again, I must stress on our side at least, the aim and certainly the hope would be that it would be a narrow and much more confined hearing to only what remains in dispute, i.e. the issues will have been narrowed that the court will need to determine.
So on this basis, be looking at a hearing sometime in the week of the 18th, yeah?
Yes.
Yes. According to my note, Mr. Conte, of Mr. Vallet's evidence, and we can look at it if we have to, at that stage, no time was being given for the fourth defendant's hard copy documents. That was his paragraph 97. And it was being said hard copy documents to the fifth defendant between 6th to 12th November, paragraph 93. And you're updating me on that, are you?
Yes, I am.
And just to be quite clear about what you are saying about those hard copy documents now, you're saying that the fourth defendant's documents are now being scanned. Now being uploaded, having been scanned.
No, sorry, my lord. We're talking about D5.
Right. Well, sorry. Let me get it right. Make sure I've got it right. Tell me what you are telling me.
So in terms of D5's hard copy documents, EY have scanned all of the documents and will begin processing them and then uploading them to Relativity. They're in the process of doing that. In terms of D4's hard copy documents, Jones Day are attending D4's offices in Switzerland to progress this, but it's anticipated that that will not be a large body of documents, because most of them, and my instructors will correct me if I'm wrong, but most of them should have a copy that's already been electronically captured. And so essentially you have the overlap, but the benefit of overlap in the sense that even if there are a moderate number of documents, they just need to check that they've already been caught. And so the anticipation is that D4's hard copy documents post the visit to Switzerland should not present a problem.
Yeah, I think that appears from Mr. Vallet. Let me just check that.
Sorry, this week, to be clear, the site visits are going on later this week.
So, sorry, say that again.
It's this week that my instructing solicitors are travelling to Switzerland to look at the hard copy documents, just to be clear. And so essentially we're getting our house in order so that way, in terms of hard copy documents, we think in very, very short order, D4 and D5 should be ready to go. And so the proposal on our side and the preference on our side would be if we could deal with everything all at once, because there's obviously good sense. But I'm not sure what my learned friend's position is, because I may have misread the letter last night. It was quite late UK time. But my understanding was there were 130 odd boxes that they haven't started reviewing. They were going to sample the boxes that were said to be irrelevant or potentially irrelevant. And there were 10 of those boxes to sample, and that hadn't been done either. And so I'm not sure what my learned friend's position is on trying to rope in hard copy documents. But when we're talking about trying to meet the 31st, I mean, you've seen the evidence, you've seen where we are. I've updated you now. I can also update you on where we are with the electronic data and the capturing and the processing. But I mean, our preference certainly would be to run the Cal algorithm on both electronic documents and to run it on hard copy documents. And we think we will very shortly be in a position to do so.
And on this footing, are you prophesying that the 31st December date will or will not be met?
I would love to be able to tell you that answer, my lord, because I was only instructed in this case recently, but I've seen from the papers that my lord asks that question quite often, and I would love to be able to tell you. And if I could divine that, I perhaps would be a much more successful commercial barrister than what I am. But all I can say is we are doing everything we can, but there are just too many moving parts. You'll have seen from the evidence, but Jones Day, EY, and both my client at D4 and D5, they're doing everything they can, including going through 5,000 pages of loose paper in a filing cabinet. And you would have seen, for your own edification and certainly mine, there are pictures of the filing cabinets.
I've seen them.
See them. So we're doing all we can, and the teams are large. It's dedicated, daily calls between EY and Jones Day. I mean, we're doing absolutely all we can. But the problem, my lord, is just simply one of I don't know what I don't know. And perhaps an apt quote on the day of the US election, but I just simply do not know, and I cannot tell you whether we'll be able to meet that. We have concerns at the moment, but one of the key variables is going to be the number of documents to review. That's just if it's 50,000, we're in one world. If it's 500,000, we're in another world. Now, my learned friend will come to this. My learned friend says we've developed a fantastic revised proposal. It cuts the body. If we apply the reduction across their population, it cuts it by 36% down to 300,000. Now, I appreciate once you apply keywords and filters, you can get that down. But if you start at 300,000 and you end at 150,000, that's very, very different than ending at 50 or 40,000. And so the main variable, well, there's two variables on our side. Obviously, there's a Swiss restrictions point, but that's out of our hand, and I don't want to go down that alley today. But the main point when it comes to meeting the deadline in terms of the non-restricted material is number of documents. And that's why my clients are anxious to get this done, contrary to what my learned friend has said. But we want this done in a way where we can get the lowest possible number so we can meet the deadline, if at all possible.
Yes, well, I'm sure you understand, Mr. Conte, that I'm inclined to hold your feet to the fire on this, but there we are. All right, let me have...
My lord, our feet are well and truly held to the fire to the point that they are burning, and they have been since my lord gave that indication at the last CMC. But in my submission, we are doing absolutely all we can. Say for I haven't been asked yet to go out to Switzerland and look through hard copy drawers. They may ask me following today, but we are doing absolutely all we can.
All right, let me hear from Mr. Sampson. Mr. Sampson, we have at least a solid proposal that's come from the defendants. The problem is this, Mr. Sampson, I'm with you in the sense that we shouldn't be where we are today. But the reality is we are where we are today, and until documents are uploaded, and that's been completed, which we know is probably going to happen over, or at least we hope is going to happen over the next couple of days. It is very hard to say what impact any use of keywords is going to have in terms of numbers of hits, and therefore what might be appropriate floors, ceilings, or anything else. That's, I think, the problem that you have to grapple with in suggesting that I get on and actually agree a whole lot of keywords, the impact of which nobody is going to be very certain of.
Yes, Your Honour. Well, the intention was to come to that. I think we've been talking about what each party wants to get out of the hearing today.
Yes.
And obviously we work with the information that we have, and we're trying to work within the deadline that we're working to. And the claimant's intention is to get there. So that's the lens through which we're looking at all of this, and that's why we've made the proposal that we've made.
Yes.
I mean, just to sort of foreshadow some of the submissions that I will be making in due course, Your Honour has to grapple with the case management issues here. The parties have been unable to agree. We are trying to find something that looks like it will give rise to a reasonable search, and arguments about proportionality are all about applying a cutoff within a range, a possible range. So I mean, coming back to the agenda for today, the way that we thought this would work is that we would talk a bit about the use of predictive coding first, and try to get a ruling on that insofar as we need a ruling. And that we hope will then inform your lordship as to how the keyword searches are going to be done. There are also a couple of points on custodians and information that we want from the defendants, which hasn't been forthcoming. But obviously the meat of today is the keywords. If Your Honour wants to hear from me on keywords up front, and then we go through the other items, I can deal with it in that way. I think it would be helpful to talk about coding.
That's the key issue, isn't it? I mean, the parties are agreed that CAL will be used and so on and so forth, that every modern sophisticated tool will be applied in one way or another. You're both, I think, agreed that floors and ceilings are a sensible approach, but none of that can really be applied until we actually have the whole encyclopedia of documents available, and they're still not available and won't be available until Friday by the sound of it. I mean, it seems to me what you've done is extremely sensible to come forward with a revised list of keywords which look to you to be realistic, but we don't know whether they're realistic or not until someone does the metrics on them. And
yes, Your Honour.
That can't be done until next week in reality, can it?
Well, the question is there time to do the metrics, and is that a useful exercise, or should the parties just get on with it, establish a population of documents, and then look at ways in the course of the review as to how they can bring it down? And we're really saying that it's that approach that the parties should be taking, given that we have to work to the 31st of December. And the risk of the approach that my learned friend is urging on the court is that it just makes the 31st of December completely unrealistic, because we're going to lose weeks whilst we have a discussion of the type that we've been having up to this point in time. And I mean, I can tell your lordship that the proposal to have a hearing in the week of the 18th is unworkable for the claimants, because I'm not available and HFW are not available in that week. So we can't do that. We also think that we appreciate the truncated timetable, but as I told you earlier, Your Honour, it took Ankura the greater part of last week to generate metrics for the proposed keywords in respect of only 5 custodians. So I don't really see how between the third, I mean, it may be that the defendants can produce their metrics by the 13th, possibly, but then, sorry, by the 11th, but then by the 13th, we won't have run revised metrics on their counter proposals, and they won't then do that by the 14th. So the proposal is not really, it cannot be one to have a continuing metrics-driven dialogue, because producing the metrics takes longer than what my learned friend is suggesting should be the timetable. So we think there are problems with the timetable. We don't agree to the ceiling approach as it's set out in the appendix. I was going to address you on that once I'd gone through what our proposal was in more detail. But in essence, having looked at it, we are concerned that it will just take out relevant documents without any real quality control process in relation to that. And so we think that that's not really the right approach to take. either. So, Your Honour, we've established the parameters for today. Looking at the agenda, then, what I suggest we do is I go through the keywords proposal that we've made, and then I'll address you in a bit more detail on my learned friend's proposal. We can then talk about
what do you think is going to happen, Mr. Sampson, if I make an order of the kind that you suggest? That I simply order the parties go ahead with these keywords. What is then going to happen in practice?
Well, what happens then in practice is that the claimants can take the keywords, they can apply them to the data that they've got uploaded on Relativity, and they can start searching. They can start reviewing. And so the first step in the review is to do the teaching review for the algorithm. So that will be done on a sample of the documents across the whole population. And then we get into the review proper, and the algorithm will present, for the most part, the documents that it thinks are likely to be the most relevant in the population. So we review the most relevant documents in the population first, based on what the algorithm thinks, but it will also produce other documents for the purposes of learning, so it doesn't get biased by reviewers reviewing the same types of documents all the time. It will serve up documents that are ranked lower down the relevance scale too. And so that way you continue to teach the algorithm, but you are targeting your review process on the most relevant documents. And then once you've worked your way down the relevancy rate and got the number of relevant documents into the predicted range that the algorithm thinks represents the proportion of relevant documents in the entire population, then you can take a view about drawing stumps on the whole process by performing some quality control checks and performing what's called an illusion test, which is about identifying the proportion of potentially relevant documents in the discarded population. So, I mean, it really does accelerate the process, and Mr. Vallat has given some evidence. I mean, he talks about numbers. One of them is in the 40s percentage-wise, and one of them is sort of 24, 25%, I think, in terms of the reduction that is applied to the documents that are actually reviewed. So we say that if you make the order, we can just get on with the review. I mean, obviously, I take the point that my learned friend hasn't had the chance to look at it. They haven't run their metrics, but they will get that data as they start their own review. And if they want to propose refinements, then they can, and we'll engage with those. But the important thing is that we have the population broadly set, and we can get on with the review, and we can look at ways to bring down the number. So those are the sorts of points that I want to take your honour through.
Yeah, all right. Well, I'm going to let you develop all that, but let me ask another question. You say you're not available in the week of the 18th. When within a reasonable time, and I'm talking about the next couple of weeks or so, would you be available for further? It seems to me that whatever I order today, we're going to be back here with an argument. And the right thing, therefore, to do is to get that into the diary.
My lord, that's incredibly pessimistic. I don't know what would have ever given you that impression in this case. We might be here for another hearing.
I live in a real world.
Strong reservations that my lord thinks we won't agree matters in this case. I apologise.
Well, I would prefer to work on the basis that we have a date in the diary regardless, and if that encourages you to agree, which it sometimes does, that would be a good thing. But when is a realistic date that we could put into the diary for a couple of weeks' time, so that whatever I order we can come back to when the parties actually see how it works out in practice, because the test of all this is always how it works out in practice. And sometimes, one's very surprised by what the documents show and the number of hits that come up on one point or another. And, there's a lot to be done here. Yes, do you know how you're placed, Mr. Sampson?
I'm getting instructions as you speak, Your Honour, and I'm looking at my diary.
Yeah.
And I think realistically, we'd be looking at the second half of the week of the 25th of November as being the sort of earliest date that we can land on. In fact, the 28th is not possible for me. So we'd be looking at, I think, the 26th or the 27th or the 29th. But the parties may need to take some time to try and clear away all the other issues, because at the moment we're talking about keywords, and rightly so. That's the big issue at the moment. But there are some other corners of the disclosure exercise that need attention.
Yeah, understood. Before you go there, how do those dates stack up for you, Mr. Conte? I mean, I tell you what my position is at present. I've got a 5-day arbitration that takes place that week, but they're telling me not to do any work on it because they think it's going to settle. And when the parties actually say that, it seems to be almost inevitable that it will. So that I can probably give you a date during that week.
Sorry, my lord. So the dates, just to repeat, the 26th or
Mr. Sampson was saying you do 26, 27 or 29.
29 is no good, but 26 or 27 works for me, my lord.
Fine. I'm just getting the lines available.
All right. Well, let's just provisionally
May I have a moment to take some instructions? There might be an issue. Hopefully not. But can I have 2 moments?
All right. Okay. Well, we'll come back to that. But let's provisionally have in our minds that 26 or 27 is a likely date.
27th seems to be the winner in terms of preference on our side.
Yeah. Well, as I say, my case will either settle or it won't. 27th is all right by me for the moment. So let's provisionally have that in mind without being firm about it. All right, Mr. Sampson, your chance now to develop the arguments you want to take today and persuade me that ordering keywords in the list that you provided is the right and sensible thing to do.
That's very helpful, Your Honour. I mean, the only other observation that I make before that I get onto that is my learned friend has submitted to you that what I said about the meeting was wrong, that factually inaccurate. We disagree with that. We think we've described it fairly in our evidence.
Yeah.
I mean, the problem is it's not documented. There's no minute of that meeting, and so I just want to say that there is a dispute between the parties clearly.
Well, I take it as read. I take it as read the parties will disagree about what has taken place. I also take it as read, notwithstanding what Mr. Conte says, that he does need his feet held to the fire.
I'm grateful, Your Honour. I just wanted to indicate that there's a dispute, but I don't suggest that there's anything that you can resolve, and so there's no point getting into it. Now, on keywords. So you've heard from me about where we've got to in general terms.
Yes.
Now the list itself is in the bundle. I don't propose turning it up. I'll describe it. It's 59 pages. It covers both sides in terms of claimants and defendants. As I said earlier, it tries to deal with most custodians on a standalone basis, with a few exceptions. So BJSS board members are grouped together. Some of D5's directors are grouped together. The relationship managers on either side are grouped together.
Yes.
But it appears to be common ground, based on the evidence of Miss Martindale Howard, that the parties' proposals generate too many hits, and it will therefore give rise to a disproportionate surge on each side. My learned friend describes it as an unworkable list in his skeleton argument of paragraph 29. So I think it's common ground that we need to move away from that list. It doesn't work. It hasn't facilitated agreement. It's a problem in the case. Now,
yeah.
In my skeleton argument, and if I could take you to that, so has Your Honour sort of printed it out? I think Your Honour normally does that.
I have. I find it so exciting that I print them out.
Well, it's excellent reading for breakfast, Your Honour. So in paragraphs 45 to 46, I've set out what the duty of the parties is, and obviously we're operating under a regime that is equivalent to Part 31 of the English CPR. So we say that what the parties have to do when giving standard disclosure is to conduct a reasonable search for documents. And the reasonableness is judged by reference to various factors, including the number of documents, the nature and complexity of the proceedings, the ease of retrieval, and the significance of the documents.
Yeah.
And a proportionate search, the rules require what is a proportionate search. They don't require that every stone should not be left unturned.
Yeah.
Then if we move on to paragraph 50 of the skeleton argument, I've set out some guidance from PD 31B and some of the authorities.
Yeah. Yes,
I
well,
say
I
that
say I don't have any difficulty with all that. If need be, I will sit down and work through a list.
We will look at the list that the claimants have put forward, but the approach that we say you should take, and ultimately we say this is why it is the right course to take, to just order the list that we proposed, is for the 5 points that we can extract from this guidance. First,
Yes.
the court should be actively case managing the issue of disclosure if the parties have failed to reach agreement. You can see in 50.1 that where the parties can't agree, then the court should give directions. Second, the court needs to be satisfied that the directions it gives will enable the parties to carry out a reasonable search. Doesn't have to be an exhaustive search, just a reasonable one. And in considering what will be proportionate, there is no right answer. This is taken from Digicel, which is cited in subparagraph 3. Mr. Justice Morgan said that the arguments on proportionality will involve choosing a cutoff point in a range of possibilities. There's no single right answer. And then the fourth point is that disclosure is a pragmatic process. So we say that the court should adopt a pragmatic approach, and Your Honour often does that. And the aim of the pragmatic approach is to get relevant documents before the court at trial, and so that trial can be disposed of justly and fairly. And so we say the fifth point then is that Your Honour should take all of that advice and be pragmatic today. And we're trying to resolve the problem that has emerged from the consolidated keywords list that has been the subject of discussion. And I've already explained that we think we've provided a streamlined list that gives adequate coverage of all of the issues and will have the effect of reducing the volume of documents to be reviewed. So let's look at the substance of it, and hopefully I can make that good. Now, in my skeleton argument, I tried to address in detail, including the annexes, I tried to address in detail the workings of the list by in terms of the way that it grouped people together, explaining why it was thought that was an appropriate grouping, because we were trying to do it by reference to parties, custodians' functions and responsibilities within their respective organisations. And so I don't propose to repeat the detail on all of that and sort of leaf through documents about showing what the parties' custodians were doing at the time. All of that has been set out in the dramatis personae to the skeleton. It's referenced. Your Honour can go away and look at those documents if necessary. But so that's the first point in our general approach. And the other points in our general approach, as I said earlier, were to reduce the number of keywords, reduce the scope of them, keep agreed keywords where what was agreed previously generated an acceptable number of hits. And so to that extent, it isn't a unilateral list, and to cover the issues. So I know that Your Honour is familiar with the issues in the case, but I do suggest that we go to page 19 of the bundle. This is the amended consolidated particulars of claim.
Yeah.
And I'd just ask Your Honour to refresh your memory by looking at paragraph 10. This is what we say the claim is about.
Yeah.
And I mean, the most important thing really today, we think, is that we need to make sure that we're being fair to the defendants. I mean, my learned friend has already said that this is a unilateral list. I don't accept that's quite right, because it draws on what's been discussed so far, but they haven't commented on it. So once Your Honour has looked at this, we'll look at the defence very briefly.
Yeah.
So then if we go to 158, that is the defence, the amended defence, and at 161, there is a summary of it. And if Your Honour looks at paragraphs 6 and 7 first, we say that the first the first point that the defendants raise is the change in the credit policy and the commercial issues between the parties. Then in paragraph 9, they run a defense that BJSS wound up BSA by following the corporate governance framework in the shareholders agreement.
Yeah.
So their defense there is that BJSS acted within the agreed corporate parameters. Then in paragraph 10, the defendants explain that the parties explored a buyout, but the question of whether a third-party sale was they say that a third-party sale was not viable, so they raise a question over that. Then in paragraphs 11 to 13, the defendant's defense is that the clients and relationship managers moved of their own volition, so without solicitation. This is sort of the autonomy argument.
Yeah.
And then in paragraph 16, I mean, 14 and 15 deal with the transfer narrative, and the point made there is that it emanates from Mr. Walia, and it's untrue. And then paragraph 16 deals with what the people in the fourth defendant's booking center were doing when they referred to sort of transfers and switches of assets under management. I mean, this is really a point of characterization of the events rather than a sort of factual dispute.
Yeah.
So we say those are the areas that the keywords list ought to cover, both in terms of the claimants you've seen and the defendants. Now, the next point that I want to make is that if we go to Malone and Friends skeleton, paragraph 29.4, it singles out a particular problem in the search terms that the claimants were requesting. And of course, these principally go to what the claimant's case is. And he says that we were looking for generic and vague terms such as transfer, the stem word terminat, which would give you words like terminate, terminating, terminated. And
Sorry, which paragraph is this?
This is in paragraph 29.4 of Malone and Friends skeleton.
29.4, sorry. I have
Yes.
9.4. Yeah.
So that's illustrative of the sort of criticism or discussion, to sort of put it more neutrally, that we were having in the disclosure meetings. Now, obviously, as you've seen, the idea of a transfer of relationship managers or of clients or of those individuals moving from BSA to BJSS AM is central to the claimant's case. And they are words that crop up in the documents. So if your lordship looks at 3728, for example, this is this email chain contains what we call the relaunch plan email. It's actually on the next page, and this was sent by Mr. Carton to Mr. Sassoon. And if your lordship goes to 3730, near the top where there's a sort of chevron, Mr. Carton says,
Hold on, not there yet.
Sorry.
3730.
Yes. There's a sort of chevron, and Mr. Carton says the conditions under which a relaunch is achieved will have an important bearing on the time needed to reach critical mass. Then the sort of fourth chevron down, he says, protect and nurture the current edge we have in the coverage of the rapidly growing NRI market or segment. This is achieved by the profile of the team currently in place, which needs to remain committed and loyal to clients, and the new entity. And then on the next page.
Sorry, I didn't pick up that reference.
I'm so sorry.
Fourth chevron. Well, yes, I got it now. Yeah.
Yeah, it starts with protect and nurture. And
Yeah,
really
yes,
the point
yes,
that, I mean, the words I'm emphasizing are new entity, which are at the end of that first clause, second clause, I should say.
Yeah, got it. Yeah.
And then at 3731, just above Mr. Carton's signature, so you're looking around the bottom of the page, he says, I'm fairly optimistic that we should retain most clients and best RMs. So you know, we're seeing words like relaunch, transfer, new entity, retain. If we go to 3753, this is a spreadsheet that was back. I'm sorry, Your Honor. I'll go back so that Your Honor can see. 3749 is the email. It's from Mr. Limai, who is one of the finance managers in BSA at the time, seconded from Alpen Capital, to Mr. Carton, and it attaches various files.
Yeah.
And one of those files is the one that I just showed you at 3753. And on the right-hand side, there is some red text starting, note, AUM assumed to be booked in year 1 if all the existing RMs are moved to the new entity. Then at 3855, this is an email from Ms. Sharaf in the Swiss booking center to Mr. Philip.
3855.
Yes. I'm sorry, Ronald. Did I move too quickly on from that last document?
No, it's just it takes time going through the electronic. I've downloaded it and so on, so that it doesn't then respond to putting a page number in. Anyway, 3855. I'm there. Yeah.
Yes. So this is from Ms. Sharaf in the Swiss booking center to Mr. Philip and Mr. George, who are at the time BSA employees, and she says, see attached the updated table of switches. And she's talking there about, you can see the attachment is switches, BSA. I think it should be figures rather than fig. And then in the next email down, they're talking about assets under management at the time of switch or transfer. And then the third email on this page, and we're going backwards in chronology, but you can see they're talking about a list of all switched accounts.
Yeah.
So they're talking about the switching of the assets under management and their allocation from one entity to another. And we say that that was going on because clients were moving from BSA to the fifth defendant.
What's AU mass as opposed to assets under management?
Sorry, can
I think that's a mistake.
Sorry, can I just interrupt for one moment? I just note we've been going for an hour and a half, and I'm always conscious for the transcribers and not kind of pushing them to their limit. So I just note that for the court, just so everyone's aware.
I'm very grateful to my learned friend for reminding me of that. I mean, perhaps the transcriber can tell us if we could keep going for another 20 minutes.
Find a convenient point, Mr. Sampson. I'm conscious too of my need for coffee.
Yes, I think we all are.
I just find a convenient point that makes sense in the development of your argument.
I'm grateful. I think AUM mass is actually AUM as at July 2014. It's a typo.
Yes, so it is. Yes, got it. Yes, you can see that from the line two further down. Yes, got it.
Yes, indeed. And then if we go to 3816, this is an email from Mr. Walia, which he sent to the nominees.
Sorry, give me the number again.
3816.
16. Oh, yeah. Okay.
I think there's been some over printing in the pagination and on the copy, but hopefully you've got it. It's Mr. Walia's email to the board of BSA and Mr. Sassoon, who I think by this point had dropped off the board, and copying in some lawyers as well for good measure. And he says, further to my earlier email below, I would like to bring to your notice that I've just been informed by a valuable Abu Dhabi client about the manner in which the transfer of the client from BSAME to the fifth defendant, the new entity in the DIFC, is being managed or orchestrated. And then this is the last one, 3818, this at the bottom of the page. I'll wait for your Honour to get there. You should see an email from Michelle Hiltman, and we can see from Ms. Hiltman's email signature that she was in group controlling at BJSS, and that is a part of the business that reported to the CFO. In her email, she writes to Mr. Lemay at BSA, and under the red text, please note the following. She refers to transfers of clients from one legal entity to another. So the point that I'm trying to illustrate, Your Honour, is that we came up with our proposed terms by reference to the documents. You know, we haven't sort of looked at what our case theory is and tried to conceptualize it and come up with keywords that way. Our proposals are grounded in the documents. And what that means is that my learned friend might say that those terms generate lots of hits and are therefore disproportionate. But the reality is that they are crucial terms in the case, and they are there in the documents. And we would submit that the documents I've just shown you, Your Honour, are highly material to the case. And so the right way of finding them is to use, and other documents like them, is to use the language that was being used by the parties at the time. However, we take on board the criticism that transfer or terminat or other words on their own might be overbroad. So let me show you what we've done in the list, which is at 4141. If Your Honour has found that, this is Annex B to my skeleton. And
Yeah, okay.
And it's the date ranges and keywords for D4. And you can see
Yes.
we start off with a group of people who we say were closely involved in the business of BSA, either because they were directors, or in the case of Mr. Carton, he was the CEO. I will pause to note that Mr. Michan is the additional custodian that we want today.
Yes.
I haven't addressed you on that. I'll do that later. Mr. Penchat, Mr. Gribby is obviously a lawyer at BJSS, but he served as an alternate director from time to time. And he was involved in the Karafi litigation on behalf of BJSS. Mr. Penchat was not a director of BSA, but he's referred to in the minutes. He had discussions with Mr. Walia about commercial issues within the business, and all of that is referenced in the dramatis personae. So your Honour can verify that. And likewise, Thomas Müller, he wasn't a director, but he was the CFO of BJSS at the relevant time. And we have found documents that show that he was concerned with the incorporation of D5. Now, looking at the keywords themselves, well, first of all, we start off with a proposal for manual review of communications between certain important parties. Now, first of all, we've got one set of sort of communications is essentially the communications between the parties to the conspiracy. And we think that's important to do because they are at the centre of what the claimants complain about. And their documents are to be reviewed very carefully. And I've cited it in my skeleton argument, and I'm just trying to turn up the relevant page. PD 31B, paragraph 27, which I mentioned in paragraph 59.1 of my skeleton, explains that the parties should consider supplementing keyword searches with additional techniques, such as individually reviewing certain documents or categories of documents. For example, important documents generated by key personnel. That's in footnote 4 on page 15 of my skeleton. And there was some common ground over this approach because there was agreement in respect of a few proposals for a sort of manual review of particular custodians' documents. So we say that is an approach that can be taken, and indeed it will mean that where documents are returned by the keywords, they will then be deduplicated against the important emails that we say reside in these people's inboxes. And the basic scheme of it is that we want the defendants to look at the emails between the parties to the conspiracy, but because our case is also that the information that was used to enact the scheme went from Mr. Carton to Mr. Sassoon, and then on from Mr. Sassoon to the people engaged in the hiring exercises for relationship managers into D5. Those people, so Ms. Yip and Mr. Clinton, ought to be caught by this manual review, and so ought Mr. Bookshi and Mr. Cunningham, who were the senior executive or chief executive officers of D5 at the time. And the defendants wanted to search emails with Mr. Wali and Mr. Kuhlman manually. So we've included that because that's something that they wanted to do. But that's the approach that we've taken there. And then in the keywords, we have, first of all, we have dropped Dubai and Middle East as standalone terms. The complaint was that they were yielding far too many hits. We've taken that on board. We've just taken them out. We've used them as sort of link words in other examples. So if we then go to item 65 on page 4144, you have new company and new entity in 66. And we've limited that by saying the document must also mention Dubai or DIFC or Middle East or private banking or PB. So this is what I meant when I talked about limiting the scope of the keywords. Previously, we wanted the defendants to search for new entity because that's a phrase we saw in the relevant documents. But in order to make it more proportionate, we're saying, well, fine, you're trying to capture new entities in the DIFC or in Dubai. So this is how we think you can do that in a more proportionate way. And then if your honour would look at 59 to 62, these are the sort of terms based on the idea of moving, and you can see that it's moving and client or business partner in 59, or in 60 it's moving and relationship manager, in 61 it's business, and in 62 it's relationship. And so that's already limited by reference to the subject of whatever is moving, but we've also then put in a requirement that the object has to be mentioned. So it's either moving from BSA or a Sarasin-Alpen entity, or it's happening in Dubai or in the DIFC, or the movement is to Safra Sarasin or BJSSAM or JSSAM. These are ways in which the fifth defendant is referred to in the documents. So we're trying to capture that. And so we think that these sorts of searches will generate a more limited, a sort of more proportionate approach to the sentiment that we want to capture, which is the idea of movement of clients and relationship managers. And then the same applies on the next page at 73 through to 76, where we use the word retain, which you saw in Mr. Carton's relaunch plan email.
Yeah.
And then in 81, terminat is limited by reference to relationships or clients or the specific document, which is the AGBCs. And then in 85 to 87, it's the transfer word or stem. And you can see that we've picked up on what was being spoken about in the emails that we looked at, the assets under management or the client, also called a business partner in the bank's jargon, or in 86, the relationship managers, as we saw on that spreadsheet I showed, Your Honour.
Yeah.
And again, it has to be that a particular person or thing is being transferred either from BSA or to the fifth defendant, or that it's a transfer that's going on in Dubai or in the Middle East. So it relates to the Middle East business. So again, we're trying to come up with a tightly defined concept that corresponds to what our case is and will yield relevant documents in a proportionate way.
Yes.
But the other thing that we've done is we've dropped requests that were aimed specifically at the other joint venture entities in the region. We think that relevant points will probably be captured by the other searches. So if we look at page 4143, then item 38 in this part of the list is close, so closure or closing, and BSA or Sarasin-Alpen, and all the other joint venture entities had the word Sarasin-Alpen in their name. So if there are closure plans in respect of those entities, they'll be captured by that search. And so there's no need to try and search specifically for those other entities. The only exception to that is that we've kept some search terms in relation to BSA Qatar. And I'll just show you one of those. So in item 16, you have Bank Sarasin-Alpen Qatar, or BSAC, as it was referred to. And transfer and business or client or relationship or RM or CRM. And that's much more limited than what we were asking for before, because before we were just asking for the defendants to search for Bank Sarasin-Alpen Qatar or BSAC. But we think it's important because BSAC was being wound down at the same time, and the management of the two entities overlapped. And so in our documents, we do find emails that involve people at Bank Sarasin-Alpen Qatar, which refer to events at Bank Sarasin-Alpen Qatar. And the claimants consider that the same sort of process was going on there. So that's relevant evidence, because it shows that there was a sort of wider, we say a wider scheme. I mean, that's our case, that there was a wider scheme in relation to all of the joint venture entities. So we've tried to take a proportionate approach to that as well. Now, as to the reasonableness and fairness of the list, we've tried to retain agreed terms from the original list where hits were not excessive. So if we stay on this part of the list, then in items 5 and 7, 5 to 7, we've just copied search terms that had been agreed between the parties and were in black text in the original list. Those are just some general searches that the parties had agreed. Reserved matter, in fact, actually goes to the corporate governance point, because the winding up of BSA was a reserved matter for the shareholders. Then, if we look at items 22 to 26 and 31 on the next page, there are more of these sorts of terms. We talk about AGMs or EGMs or general meetings. These are all terms that had been agreed between the parties, and so we've just copied them across because they didn't generate an unreasonable number of terms. Then in 35 and 45 over the page, again, we've taken agreed terms in relation to the deadlock reserved matter procedure. And I will pause after this, Your Honour. At items on page 4146, items 88 through to 99 are all search terms that had been proposed by the defendants and which were agreed by the claimants. And those relate to communications with Mr. Walia about the business and its future, or specific meetings that took place between the parties, or in 97, the credit policy issues, the loan to value or average daily traded volume, which relate to the kinds of securities that were being sold to BSA's customers on leveraged finance terms. So we've tried to take what had been agreed, and in particular what had been agreed in relation to the defendant's case, and maintain it in this list. Your Honour, I think that I'm going to move on now to some other types of custodians. I think that's a convenient moment to pause, so that the transcriber can have a break and we can all get a coffee.
All right, very good. Well, let's take. What do you make it? 38 minutes past or thereabouts? Okay, well, we'll come back at 10 minutes to the hour, please.
I'm very grateful.
Thank you, my lord.
When you're ready, Mr. Sampson.
I'm grateful, Your Honour. I'm going to try to sort of pick up the pace a bit on these keywords. If we go to 4148.
Yeah.
We're dealing here with then at the bottom of the page, the BJSS and JSSH board members. And the point I just want to make is if Your Honour scans the keywords, Your Honour will see that they're really focused on the strategic issues, the Karafi litigation, and the corporate governance deadlock process. So we say that these are things that would have come up to that level of the bank and with which it would have been concerned. So we're taking a targeted approach on the keywords here. We've reduced the list to 19 terms, which we think cover the most important issues that this group of people would have dealt with. I mean, to give an example, 4 relates to the cost of funds. I mean, that was the credit policy issue. 5 is the reserved matter. So that's the corporate deadlock process and that led to the winding up. Obviously, Alpen or ACCL or AAA will be discussions at that level in relation to the joint venture partner. And in fact, AAA is a likely candidate for an area where the parties will be able to formulate exclusionary searches, because I suspect AAA will produce credit ratings reports. But that's an obvious category that can be easily excluded to bring the numbers down. So that's the sort of thing that we talk about when we talk about exclusionary searches and removing documents from the population quite easily.
What was single stock?
That's
Item 6.
That's proposed by the defendant. So I understand that that's something to do with the securities that the that BSA was marketing to its clients, and so they were investing in particular kinds of stock, and they were doing it with leveraged finance, and that took the business out of the parameters that the bank was comfortable with. So we've always understood that to be a term that the defendants think relates to that basket of issues.
Yeah, not diversified investment. Yeah,
Exactly. And then, so 15, we have non-resident Indian and private banking, and you saw a reference to that in Mr. Carton's email. So that's the business segment that the bank was really interested in, that BSA had. So again, we say this is dealing with strategic big picture issues. Then if we move on to 4152, I mean, all I can
just ask you, Mr. Sampson,
Yes.
in a sense, why are you showing me all this? I mean, I'm prepared to assume that because you've applied your mind to this is a perfectly reasonable starting point on any view.
Well, that's precisely what I was trying to show, Your Honour. That I was about to say that I'm trying to give Your Honour a flavour so that Your Honour can see the sort of approach that we've taken, and it's not a sort of one-size-fits-all scattergun list of keywords. And so, obviously, we were looking at the first group of custodians have the most expansive list because they're the most sort of closely involved, closest to the action, most important people. Now I'm just showing you some examples of people who are sort of involved, but it's a sort of at one remove. So I mean, I'll just do another example and then move on. 4152 is Enid Yip, and I'm just alighting on that because we've talked about Miss Yip already today. She was responsible for the hiring exercise in relation to the Bank of Singapore relationship managers. So she would have been in communication with Mr. Bookshi, who was at Bank of Singapore. We're interested to see if she was in communication with Mr. Clinton and Mr. Cunningham, because they were, Mr. Clinton went on to hire the BSA RMs, and Mr. Cunningham was the SEO at the time. Ms. Yip was based in Singapore. No, I'm so sorry. She was responsible. She's the head of division in relation to Hong Kong and the Far Eastern business. So we've put Dubai in as a keyword because that wasn't her area of the business. And so if she's talking about Dubai, we think that she's talking about the Middle Eastern business. She's talking about BSA and asset management. She's not talking about the things that she was routinely responsible for. And then transfer at 17 was the one that was objected to in the meeting because it produced 902 hits. But your Miss Yip would have been involved in there would have been communications with Miss Yip about why she was hiring this team. On our view of the world, she would have been wondering why she was being asked to lead a hiring exercise in relation to a team that was going to go service clients in the Middle East, which was not her business segment within the bank. So we think that there would have been discussions about transferring clients and relationship managers. And because it's only yielded 902 hits, and that's under the floor that we proposed at the meeting, we've just left it as is. We don't think that this is a disproportionate term in the context. So that's the approach that we've taken there. I'll just move on to D5 just to show that we've sort of done the same kind of thing there. So if we look at 4159, this is now we're on to D5s. Our proposals for D5, and we've got 13 terms in relation to the relationship managers, many of which were agreed already anyway, and they are aimed at the process of terminating the relationship with BSA, which is what we say is the sort of critical element of what the relationship managers went off to D5 to do. And so they were procuring the transfer by means of the termination of investment services document, which was signed by clients, and they also signed the additional general business conditions of D5. So we think that a reasonable search should encapsulate those sorts of documents, and that's what these keywords are aimed at. So again, it's targeted at what the custodians were actually involved in terms of the case. Then if I take you just to a few examples of the claimants lists, by which I mean the list for the claimants custodians.
Yeah.
At 4170, we start with Mr. Walia, Mr. Lakshman, and Ms. Ahmed, who, well, Mr. Walia is obviously the founder, and he was a director, and he was the SEO of BSA for a time. Mr. Lakshman was the COO of BSA, and he's sort of Mr. Walia's right-hand man. Ms. Ahmed was the HR manager, and later on she was a director, sort of after the scheme had been, we say, enacted. So in late 2014 through to early 2015, she was then a director of the company. Now these terms are therefore expansive because these are important people, and in particular we've tried to take what was agreed before. So item 8, for example, is the buyout term. So that relates to the parties' negotiations for a sale of the business to one or the other shareholders. That was agreed. 10 to 16 are the defendants' proposals for credit policy related terms. They had more than that, but we've looked at them and we've taken a view that the most important ones will relate to the credit manual or the credit policy. And so we've picked on those. The other ones we thought were broad because they just talked about and overbroad because they talked about defaults on loans or loans being rejected or denied. So, you know, that's getting into the routine transactional business of the business, and is likely to be disproportionate. And indeed, we took the view that they were generating too many hits. But we've tried to retain what we think is important to the defendants in this list. Then if we look at item 18, again, that's the deadlock point. Items 20 on the next page, items 22, 26, 31, and 37 all relate to the spreadsheets that we've seen being provided by Mr. Carton to Mr. Sassoon, or which were provided by Ms. Ahmed to the bank, but only for the purposes of getting approval of bonus proposals for employees. So we say that these are to do with the confidential information that was, on our case, exploited by the bank in order to hire RMs. So these keywords cover an aspect of our case. I've been focusing on the defendant's case, but just to show you the coverage, that's part of the claimant's case.
What on earth is pipeline number?
Pipeline numbers was a spreadsheet which Mr. Carton sent to Maria Ganner and Elie Sassoon. And there's a dispute over who Ms. Ganner was. We say she was actually a Swiss relationship manager, and the defendants say that she was a PA, but her LinkedIn profile says that she was a relationship manager, and that's referenced in the dramatis personae. And he provided numbers. The document provided numbers in relation to the anticipated business that would be done by reference to relationship managers. So if we go to 3733, that's the email. And then over the page are the pipeline numbers. And you can see they are arranged by reference to the teams and the relationship managers. So you've got assets under management at the top. NNA is net new assets. So this is to do with the business that the relationship managers are bringing in.
Yeah.
And this is in, this is the 28th of November 2013. So this is around the time of the relaunch plan email.
Yeah, I understand. Yeah.
So that's, again, a targeted search because it's by reference to a specific document, and we want to see what discussions were held in relation to that internally in the bank.
It's basically a pipeline means the business coming in. That's what it's about, isn't it? Yeah.
Precisely.
Yeah. Yeah, got it.
Let's move on to 4177, which is the relationship managers and the other employees, the sort of assistant relationship managers. First, we start with our proposal for the search is that all client numbers and names ought to be searched to return the documents that relate to the clients.
Oh yeah, I've lost the page. Which page?
Sorry, 4177.
So we're in annex. I'm actually looking at this in hard copy. So
yes, right. It's page 8 of Annex D.
Oh, right, got it. Yeah. Yeah.
And so if we start off with the client search. So you see this is the bottom third of the page, and it's all client numbers and names of the former clients that have been identified in the lists that were exchanged pursuant to your order from the first CMC.
Yeah.
Then we say, use these exclusionary terms to strip out irrelevant transactional documents because we're not interested in those. And then we say, search for things that the relationship managers would have been saying to their clients about what was happening in BSA. For instance, the Carafi litigation or credit manual and credit policy issues that the defendants are interested in. And then at sort of 14 to 17, it's the closing of the account that we're interested in. In 23 through to 25, we've picked up on language that Mr. Walia was saying Mr. Cunningham of BJSS AM was using at the time, because he talks about Mr. Cunningham saying that BJSS and BSA would merge. And then Mr. Astruc in the same email chain accuses Mr. Walia of telling clients that BSA and BJSS were divorcing. And so we think that this might be language that was being used by the relationship managers. If that's what Mr. Walia was saying to them, then they might have been passing that on to clients and sort of telling them that something was up in the bank and that there was going to be a change. And then obviously at the bottom, sort of from 30 onwards, we're into the terminate type keywords. 36 again actually is one of the credit policy keywords: tighten or change of policy or credit parameters or loan parameters. So again, we say this covers both sides of the case, and it's targeted at what one can imagine that the relationship managers would have been saying to the clients. And then at 4180, we're on the page already, and this is the last one, the last example. We've got Prabhakar, Limai, and Binu Nair, who are the finance people in BSA. And so we've focused the terms in relation to them on financial issues, which include distributions and dividends, because Mr. Walia proposed some dividends that the board rejected, and the defendants rely on that. Then at 8 through to 10, the liquidation and the insolvency, and as your honour remembers, we rely on the prospective insolvency for the duty to creditors point. And then 11 and 12 are to do with the sale of the business and the valuation of the business. Likewise 13. And then skipping past a few, we have put in some of the transfer and business points, because you saw that Mr. Limai was emailed by Ms. Hiltman of Group Controlling, talking about clients being transferred from one entity to another. So he was obviously privy to some discussion about that. So, Your Honour, the reason I've done that, I'm sorry it took a bit of time, but the reason I've done it is to show you that we think this is a sort of intelligible list of keywords. They make sense by reference to the case. They're even-handed, And I mean, there are still a lot of keywords, but they're far fewer in number than the previous document that we were working with. And so we say that that makes this a reasonable starting point, at least, for the parties to be able to get on with their review. So the next area that I need to address, and we'll move away from the lists, you'll be pleased to hear, is the volume of documents generated by the keyword searches. We've tested it. I've already told you that we've done that by reference to a sample of 5 custodians, because that's all we could manage in the time available. And the results are at 4099 in a spreadsheet that you will need to zoom in on. So I've got it at 200% to be able to read it, because I think it's sort of been produced in A3 format. And the key, so I mean, you can see in the sort of big block that there are the 5 custodians, and Ankura have set out the date range, and they've set out the hits, and they've provided a comparison of the old hits against the new. And we'll take a big picture approach to this. The total documents with family documents generated by the searches for these people are 150,000 odd, compared to 238,000 odd last time.
Sorry, I've just managed to lose the document. What page was it again?
It's 4099.
Yeah.
So it's 150, let's call it 152,000 down to 238,000 in the totals, which includes the family documents. So those aren't necessarily documents that have responded to the keywords. They're documents that are linked to a document that has responded to a keyword. And as my learned friend said, and as I say in my scopes and argument, we make that to be a reduction of 36%, which we say is substantial. And doing the best that we can with that, we've tried to work out roughly how this would then apply to the range of our custodians. So we've applied that discount to the population that was generated by the agreed search terms, plus our proposals, leaving out the ARM Dubai account, because that's a sort of separate type of search. It's like the RM searches. And that number was 397,000. When you apply the discount, it comes down to 254,238 documents. Then you need to add the searches for the client names and numbers in the relationship manager's mailboxes that I showed you. But we think, so that number was 135,700 odd, but we think it can come down by a third through the use of the exclusionary searches that I showed Your Honour. So that number is then around 90,000. Then one adds the ARM Dubai results, which were 22,300. We haven't applied exclusionary search terms to that yet, but we think that we can do that, and it will bring the population down, because that's a relationship manager group email account. So it should perform similarly to the relationship manager's searches. If you add all of those numbers up, you get to 366,121 documents. And in my skeleton argument at paragraph 67, I gave a different figure of 304,864. I haven't been able to reproduce that number. I think it must be an error on my part, Your Honour. I apologise to the court for that. I apologise to my learned friend. Obviously, the number's gone up. It's 366,121. But again, we say that represents a reduction compared to the position previously, because we were just on the search terms proposed for the claimants custodians around 400,000. But the 366,000 takes account of some other numbers that need to go into the pot. There are a few caveats that I must raise with the court. The first is that this figure only relates to the custodian's email data. It doesn't relate to the custodian's sort of shared file data. I have asked this morning, and I have got instructions that what Ankura describe as the loose files, so that those would be files held on network drives for custodians. The total population across the whole universe is 92,000, which is not particularly large when you compare it to the documents in the mail containers, which are just over 3 million. So if you can see how we get from 3 million down to 366,000 on our proposals, then if you apply keywords to the custodians' sort of loose files, as they're called, then that 92,000 number should come down significantly. But we haven't tested that. It wasn't part of the testing that Ankura did. We would also need to add in non-custodial documents held on the servers. I do have a figure for that. It's at 4,488 of the bundle. Your Honour doesn't need to turn it up, but we produced and I'm afraid to say we produced it last night, but we produced a list of proposed terms for non-custodial documents, which are based on what I've just been showing you, really. And when we apply those to our population of non-custodial documents, we get 4,763 documents to review, which we say is quite small. We'll need to add in the liquidators' investigative papers as well. We've agreed to search those. But Mr. Hyder's investigative papers are likely to contain a high degree of duplication because he had a data room in which he had pulled out documents from the servers and was looking at those. So that will need to be deduplicated against what we've actually, the full extraction of the servers for the purposes of the document review, in terms of what's been identified as sort of relevant custodial data or relevant non-custodial data. And then, again, we're talking about what Ankura describes as loose files. Generally, there are far more emails than there are sort of Word documents and PDFs that people generate in the course of their work. So we don't think this is going to be a large repository. And then, of course, we need to deal with hard copy documents and audio recordings, but those will be dealt with separately anyway. So we think that we have got the baseline figures down quite a lot through these searches. And there are other further reductions that can be applied quite easily. So first of all, we've talked about exclusionary searching. I mean, we've managed to reduce the relationship manager's documents by a third. The defendant's evidence is that they did a similar exercise on some of their custodians, and they reduced a population of 527,000 documents by 22% through exclusionary searching that they identified. They stripped out 116,000 documents by looking for things that were sort of transactional in nature. Then there's email threading, which takes individual emails and compares them to longer chains of emails. And if that email is in the longer chain, then it comes out, it doesn't have to be reviewed separately. Now, we applied that to the population of documents generated by what were previously the agreed searches, and that population came down by 24%. So again, it's quite a big reduction to be made on the documents just by applying email threading. And then there's the continuous active learning point. Because we've gone in a different order, we haven't talked about, compared to the agenda, we haven't talked about that in detail, but Mr. Valat's evidence on this, which is at page 987 of the bundle, in paragraphs 116 and 117, he refers to cases where COW reduced the document review by 24% and 43% respectively. So again, we're optimistic that we can get the numbers down, starting with a population that we've already tried to reduce. And you've seen we've been quite targeted and we've been quite reasonable in the terms that we provided. Ultimately, the documents are the documents, and the language that's relevant is the language that's relevant. And so I think it will be difficult to get down to a number like 50,000 as a baseline number, which is what my learned friend was talking about, because it is a bank. They do talk about transfers in various contexts, but that is the language that was being used in this context, and so we must search for it. But the parties have other techniques at their disposal, and they'll be able to get the baseline number down, and that gives them a good chance, we say, at meeting the deadline. Certainly, that's how the claimants feel about the exercise, having looked at the numbers that we've generated on a provisional basis. And we think that this is The time is tight. We will have to throw resources at this, but it is achievable in the time available. And as I've said earlier, if there are issues on relevancy rates, if actually these keywords generate lots of irrelevant material, that will become apparent from the teaching review and probably the early stages of the wider review, which is supposed to look at what the most relevant documents are first. And if those are not particularly relevant, well, then the parties are doing a QC exercise by looking at that, and they will have to liaise about tweaking the keywords to make them better. But ultimately, all these techniques can only really be understood, and proposals can only be formulated if one actually looks at the documents, because one has to look at what might be a sort of irrelevant type of document that's in there, captured by the keywords, and then look at the language that's used in it, come up with a keyword that will strip that document out, but not other relevant documents, and then apply that and see what it does to the population. And so we say that really, Your Honour should just order the keywords that we propose as, at least as a starting point. The parties then can actually move forward with their review, but they'll be able to identify things that they can do to the population to get the numbers down further. And that can only really happen once we start. It's not a theoretical exercise. Now, the defendants also suggest that a near complete set of data should be uploaded. Our view on that is that that's all the more reason to order these keywords, because they will cover the bulk of the documents, because there are, as I've already said, the majority of documents in the case will be emails rather than standalone documents or loose files that the parties have generated. So this will establish a good base for the parties' review. It will establish a good base for teaching the COW algorithm. And if we introduce new documents through other searches into the population, COW will be able to apply its learning to those documents. And if it doesn't know whether a document is relevant or not, it will assign rank 50 to it, which means it can't put it either side of the relevancy line. And if the system has been calibrated in the right way, i.e. the right option has been selected, then those sorts of documents will be offered up to reviewers so that they can tell the algorithm whether they're relevant or not, and the algorithm then learns from that process. So we don't really see the introduction of documents later on as a significant problem, particularly if we capture what we say is the most relevant population, that's sort of the baseline relevant population now. Another approach would be to run a separate COW model for different types of documents. So the hard copy documents, which are likely to be different in nature to the emails, could go into their own COW model, and that COW model can be taught on the documents within that pool. Obviously, you have to be careful to sort of code things consistently between the two different models, but that's another way of avoiding upsetting the first model that has already been trained if you're sort of introducing documents at a later date. But it's not, we don't think that that would necessarily be required, but it's an option. So
can you just remind me of the types of documents that are going to be hard copy where they're not duplicative?
Certainly. I mean, I can only really do that on our documents because we haven't seen hard copy documents from the other side. But
well, my impression on hard copy documents on the other side is that they're likely to be, so to speak, the formal application forms and business documents that are signed by the individual investors and the like. But I may be wrong about that.
Well, they refer to the KYC documents and the
exactly
relationship inception documents in their evidence.
Yeah, exactly.
So yes, that's obviously. I mean, all of that is supposed to be scanned in.
Yes,
put into Avaloq. So it should be there electronically anyway. But
on your side of the fence,
on our side,
what are they on your side of the fence? The hard copy documents.
So the various boxes, and I mean, I'm trying to find the relevant letter for Your Honour to just look at. But in essence, we have boxes that contain runs of board minutes, So those can be identified as relevant or not relevant quite quickly by reference to the date range. Client agreements, AGBCs, again, that can, you don't need to read the whole contract. You just need to see which client it's relevant for. I mean, you might even take the view that a client contract isn't really relevant to the issues. But if you do take the view that it is, then it depends on the identity of the client. And various financial papers. In fact, if your honour goes to page 4455, this is a letter we sent last night, but it actually repeats what we said in Braganza 8, which is filed for the first CMC. And paragraph 5 identifies what hard copy documents there are.
4455.
Yes.
Oh.
It may be that it hasn't made its way into your honours bundle.
Well, it hasn't, because I downloaded this bundle on Monday, I think.
Okay.
Yeah.
Right.
Never
Well,
mind.
there are various boxes from different departments: accounts, HR, compliance,
Right. Okay.
operations, and admin. And we're interested in the compliance and operations files. And in the accounts department files, we've got very detailed indexes of them. There are 6 boxes, which are the board minutes and financial papers, and there's also an addendum to the shareholders agreement, so that would be relevant to the defendant's corporate governance case. And then there are 15 boxes of HR files, which contain staff files, and those one would think will contain resignation letters from RMs, and those will identify why they were resigning at the time that they did.
Yeah.
Which may not be that illuminating anyway, but it's all quite stuff that's quite easy to handle. It's not going to take long to review that. So that's the hard copy documents. I mean, back on the list, Your Honour, at this point in time, the parties just need to get started, and the parties need a reasonable starting point for doing that. In my submission, for the reasons that I've explained today, the claimant's proposals are a reasonable starting point. There is always some refinement and discussion between the parties as the review progresses, and there will be ways of bringing the numbers down. But let's get on with it. Getting on with it will help us identify what refinements need to be made. And so I invite you to direct the parties to use the claimants lists as their starting point, so that they can get on with reviewing from this week. Now we also have a list of non-custodial documents, which was sent last night, and on that basis, I don't think it's in your bundle, so I can't show it to Your Honour. So it may be that we have to leave that for another day. I was hoping to show it to you today.
Well, if I just go into the case management system, I can probably find it, can't I? It should. You think it'll be in the case management system as of today, will it?
Well, I think so.
Yeah. Okay. Well, let me just get rid of this for the moment. All right, bear with me. with a what page?
So the list is at 4486. The letter of last night is at 4484, but I don't think we need to look at the letter. I mean, the point about that is just that it went over to the defendants last night. They haven't really had a chance to look at this, of course. But it's a relatively short list because it's 2 pages long. And if your Honour has found it,
Okay.
then the scheme is that we do a manual review of the HR files for identified members of staff who moved over, we say, to D5, or who are being searched in connection with their emails. And then there are keyword searches which are based on the themes that we've been looking at already. So the Carafi litigation, Miss Brander, because she was in the booking centre, the Alpen entity that was set up around the same time as the 5th defendant, and to which some of the staff moved.
So I'm having trouble with this
I'm so
new
sorry.
system. No, it's my fault. Under this new system, which I haven't yet mastered, where do you put in the page number to get the page you want?
I don't know, because I download everything, but it may
sorry to interrupt, but I know that we're 2.5 hours in, and we were scheduled for 2.5 hours. I have had my 7 minutes of glory so far, but if my learned friend could just give an indication as to how much longer he's going to be, I'd be very grateful.
About 5 minutes.
Can you help me on how to get the relevant page number into search it? Well, actually, better still, if I go down to which section are you in of the bundle?
L.
Oh, well, I haven't got L. L doesn't appear in the case management bundle that I've just gone to, which is today's bundle, I take it.
Well,
very odd.
In that case, Your Honour, let's move on from it.
Yeah. Okay.
The parties will have to. I'm just about to get some instructions. The parties will have to. Well, I'm told that it's there, but
is it?
We're unable to find it.
I can't find an L in the case management bundle that I've just gone into the system to get it. Having downloaded one on Monday, and no doubt it has moved on, but anyway, there it is. Right. No good for the moment.
So be it. I mean, there's nothing more I can say about that in that case, Your Honour. The only other point that I was going to make would be that if Your Honour is not with me about the list that I've shown Your Honour, then we submit that at least the claimant's proposals for the claimant ought to be approved, so that the claimant can get on with the review. That obviously covers things that the claimant considers should be searched, and in my submission, the defendant's not going to be telling us not to search that kind of material. There may be other things that they want to add to the population, in which case it's about adding to the list rather than taking away from it. And so the claimants can use it as a starting point, and you should at least order that so that we can make progress on our side. But the best approach would be to... I'm
terribly sorry, Mr. Sampson. I was still fiddling with trying to find this document. I found section L, but that won't do. Can you just repeat exactly what you said? Because I wasn't listening to a word of it.
The alternative proposal that I have, if Your Honour is not with me about ordering all of the lists for everybody, is to order the claimants list for the claimants to use as their keywords, because the defendants in my submission are unlikely to say that we shouldn't be searching for things that we've identified in that list. They may say that there are things that they would like us to search for which are not identified in the list, and so those would be additions to the list rather than subtractions from it. And so that gives us a starting point on our side, and we can make progress, and the defendants can stay behind if they wish.
Understood.
Now, just very, very finally then, on the defendant's proposal, I told you at the outset I had some quibbles with it.
Yes.
I mean, the essential reason, as I've already said, not to order it is that it will introduce further delay and stop the parties from getting started. But Appendix 1, we think is somewhat unworkable, because if your honour finds it, then paragraph 1.3a is far too expansive, because what it provides for is for documents to be taken out of the population if a family document is to be extracted without reviewing all of the other documents. Now, I understand that that's a sort of a shortcut, but if there is an attachment that is dealing with an unrelated matter, but the body of the email deals with several matters, including a relevant matter, then you will lose the bit of the email dealing with a relevant matter. And so this isn't the kind of pragmatism that was advocated or proposed.
Well, it's the second half that you're objecting to, is it? That regardless of any other search terms that appear in the particular document or its family members?
Essentially, yes, Your Honour.
I put a large question. I put a large question mark beside that.
Right. And then paragraphs 2 and 3 require the parties to agree the ceiling and the floor. Well, I've already told you we tried that in the meeting on the ceiling, on the floor, and we didn't manage to agree it. So again, I wouldn't. The court should not hold its breath and wait for the parties to agree and come back to sort of resolve some issues. And similarly on paragraph 4, it provides a framework for agreeing how to refine searches. I mean, that's what we discussed in the first disclosure meeting, and that's what we've tried to apply to our proposed list. It's just, at the end of the day, it's just an agreement to agree, and it doesn't move the process on today if you order this. So we don't think this is a particularly good alternative to what we're suggesting, and we'd invite you to go with our proposal.
What do you say the result would be timing-wise if I was to go down Mr. Conti's line, or some variant of it, which might be slightly speedier than he is currently suggesting?
Well, then it's likely that the
supposing we get to a hearing here at 27th of November, where I have to sort out whatever then is still not agreed. But assuming that in the meantime, some sort of progress has been made, certainly on your side with use of keywords and search terms and so on, where is that going to take us in the context, one, of completion of disclosure, and two, in the context of the whole timetable up to trial? Are you able to help me at all on that?
Your Honour, the submission on that that I would make is that if the parties are, the claimant's approach would be to get started and teaching the algorithm as soon as it's possible. So if we have a set of keywords for us, then we can use that to get on with the review. And we think that if we can get started this week on that, then we have a reasonable prospect of meeting the deadline if we can use CAL effectively and reduce the volume of documents through the other ways I've been talking about. So, but if the parties are still arguing over what the body of keywords should be, I mean, there are two approaches. One is the parties sort of work with what does get agreed along the way. But the problem with that is that the defendants say that you need to settle the whole universe of documents before you can teach the algorithm, because that will provide the best quality teaching. Our position on that is that each time that the keywords change, you will need to do a teaching review for the algorithm to cover the new keywords or the additional documents. So it will just be a sort of stop-start process. It won't mean that you have to go back and re-review everything that's already been reviewed. But in order to make sure that the algorithm is working in a statistically valid way, you then need to do these sort of teaching exercises. And so it's not the optimal way of doing it in our submission. And of course, it will delay discussion and agreement on other areas of the disclosure exercise that need to be dealt with. So I sort of mentioned at the outset that there are some things to deal with. Those will be the proposals for non-custodial searches, audio recordings, and foreign language keywords. Now, if we're still arguing about the electronic data, the main body of the electronic data keywords on the 27th of November, then it means that we probably aren't applying our minds very hard to how to deal with the other issues that exist in the disclosure exercise. And so, again, my submission is that Your Honour can and should just move the parties on. And in terms of the knock-on effect, because if we don't get started properly until the beginning of December, then it seems likely to me that the 31st of December will have to move. And the position at the last CMC was that that was really the last date that we could look at in order to preserve the current trial timetable. And obviously, what we must avoid is losing the trial date.
Yes. With the other smaller elephant in the room being the question of restricted documents.
Well, Your Honour, I mean that's one of the areas that we haven't covered yet, but that touches on Avaloq, and we say, I mean, our submission on that is that it's available to the fifth defendant, and the defendant, we think, can pull data from it. So anything that's on Avaloq, we say, isn't going to be subject to Swiss law restrictions. We've been saying that for a long time. I can show you some evidence on that later.
Well, we may have to decide that at some point. Yes. All right. Anything else you want to say at this stage, Mr. Sampson?
No, I'm conscious I've taken up a lot of the hearing time.
Yes. All right. Mr. Conte, the first question is whether you want to address me on any of the details of the keyword searches that have been put forward as the attachments to the skeleton argument that Mr. Sampson has produced.
I would. So my first point is that I won't take the court through it, but there are some background points that I was going to about why we are where we are. Then I was going to take some general points, which is the only points I can make, but the general points I think are very problematic for my learned friend's position. And then I was going to respond using some examples we've been able to pull together rapidly in the last couple of days. But I do need to make the point, and it was the first point I was going to make, is that I know my learned friend started off by saying this is not trial by ambush, but I'm afraid it's precisely what's happened. And I don't want to.
Well, I've got the point that you're not in position to deal with all the detail of it, which is why I asked you the question as to whether you wanted to address me on any of that at all.
No,
I'm keen to hear your general points about it.
Yes,
about why you think it's inadequate.
Yes, so I think the general points are where I'd like to start, and then I just have a couple of examples, and I'd particularly like to focus on some of the things my learned friend has submitted moments ago, because I think they do tend to bear out my point. So 5 high-level points is essentially where I'd like to start. So in paragraph 51 of my learned friend's skeleton, he notes that they've proposed a new list of keywords, and then they seek to set out some advantages. This is at 4199 of the bundle. Sorry, 4119. Sets out the keywords of the proposed new list and sets out the purported advantages of simply adopting their proposals. What he doesn't say there is obviously the biggest disadvantage, which is the court would be endorsing a set of keywords without having tested them against a set of counter proposals or any metrics. And we say that's not the way this process normally works. Normally, the court has two different comparing proposals before it, and it can evaluate them, but most importantly, backed by evidence, backed by numbers. And that, in circumstances where the biggest objection the defendants have is proportionality, that is absolutely critical. So we say, first general point, greatest disadvantage of the claimant's approach is it makes a decision necessarily unfair. The second point, and this is turning to 55 of my learned friend's skeleton.
But it may not make the decision unfair if you've been given a fair opportunity in the past, but it plainly is not the basis upon which decisions are usually taken.
Well, my submission there is just haven't been given. I mean,
I've got that point. You haven't had the time to deal with this in detail. I understand all of that.
But it's not even that. I mean, with all due respect to my learned friend, it wasn't a slight revision of where we were before. It wasn't an excursion on the version, as it were. It was a radical resetting of the task. Now, I'm going to come to agreed terms in a moment, but my learned friend made the rather surprising submission that, well, we just deleted some of the agreed terms because they were excessive. It's an incredibly surprising position to take. So the parties have agreed something, they've both agreed for it to go in, and the claimants have unilaterally deleted some of those agreed terms. I was really taken aback by that, but I'll come back to that in a moment. My point is that I hadn't even appreciated that they'd deleted some agreed terms because we haven't been provided with a comparison document. So that's just one example of a minefield that was there, and that had my learned friend not raised it, I wouldn't have had any knowledge of it. And that's the danger. The second point is my learned friend at paragraph 55 of his skeleton contends that the parties have not been able to find a reasonable balance between keywords that are unrestricted in scope and keywords that are too constrained. And then he gives an example. And if you look at page 4120, the example search string he gives is one of the examples that the fourth defendant put forward, which is Astruc or Sassoon and BJSSAM or new entity. And that he goes on to say that this is unacceptable because, among other things, this string would only capture emails between the first defendant and the second defendant, including the words BJSSAM or new entity. However, that's incorrect. I'm instructed that the defendants proposed this search string specifically in relation to the third defendant, i.e. Mr. Carton, so that, for example, if Mr. Carton sent an email containing a relevant combination of those words, it would be caught. And so the focus on the results that my learned friend has put in his skeleton, and the results in particular that would be thrown up for D1 and D2, is misplaced. Next, in paragraph 55.1D, a bit further down on the page, the claimant seemed to suggest that the fourth defendant's proposed search string is inappropriate because it would not pick up emails involving Mr. Marcelo Sersman. However, in the very limited time that we've had available, my instructing solicitors have gone back to the defendants, they've run the search, and it appears that the proposed search returns more than 900 responsive documents which mention Mr. Sersman. So that criticism misfires. Next, 55.3. So the claimants now advocate for the following search string: new entity and Dubai or DIFC or Middle East or private banking or PB. Now, pausing there for a moment, that's a very wide string because your and is limiting, it's conjunctive, your or is obviously disjunctive. So it is going to catch a decent amount of material. Second point, private banking as a term in PB are entirely new search terms. So defendants have run this particular string, and the results for example, Mr. Sergio Penchas is 546 hits, and for Mr. Marcus Affolter, it's 2,201. Well, what the defendants had proposed was take the original search string that they had thought of and just add a limiter, which is the way you normally do this. You have a particular search string, it's too broad, you add in an and at the end and you limit it down. They took the original search string and they added a limiter, which was just adding new company. And when you add that to the original, correct myself. They added in one more term in order to expand the search, not limit. They added in new companies and all new company to expand their search to try and meet the claimant's concerns. And when they expanded the search and they ran it on the documents, the results were Mr. Penchas, 426 hits, which is 120 odd less than the claimant's suggestion, and Mr. Affolter, 1,170 hits, which is roughly 900 hits less. So by simply adding an additional term that expands the string, it appears that defendants were able to reach the reasonable balance that my learned friend said was so elusive. Next, paragraph 57 of my learned friend's skeleton. So the claimants claim that they've devised a set of lists which contain fewer search terms. And he repeated this in his oral submissions moments ago, but which they say custodians have been grouped together according to their level of involvement. However, my general point is that the desire to do the latter undermines the former. And I'll give my lord an example. focusing on Mr. Eric Sarasin, who's a custodian for D4. In the consolidated list, and I won't ask my lord to turn it up because there's really no need, but in the consolidated list, there are 35 total search terms, agreed and non-agreed, suggested for Mr. Sarasin. But when you look at my learned friend's radical new model, Mr. Sarasin is placed in the same category as, for example, the individual defendants, such that there are now 102 search terms suggested for him. So I'm not sure how that results in fewer search terms. But let's take another example, Mr. Rajiv Philip, a D5 custodian. So when you look at the consolidated list, and again, I won't ask my lord to take it up, to turn it up, the consolidated list, Mr. Philip, 42 total search terms. Now, in my learned friend's new model, he's placed in the same category as Mr. Isley, and there are now 102 search terms suggested for him. So again, we have 2.5 times the number. And I pause there to note that the claimants have placed Mr. Phillip in the same category as Mr. Isley. They've put them in the same category, purportedly on the basis that there's been an alleged, quotes, similar level of involvement on the facts. But we find that problematic. So Mr. Isley held the position of D5's company secretary in the period from July 2013 to April 2015. Therefore, he was involved during the period of the alleged scheme. And you can see that from paragraph 4137 of the bundle, which was my learned friend's helpful cast list. But Mr. Phillip was only employed by the fifth defendant in March 2015, which is after the period in which the alleged transfers are said to have occurred. And I take that from page 4138, again in my learned friend's helpful cast list. So just with that one example, and I appreciate it's only one example, but we are very unsure about whether the proposition that the custodians have been grouped together based on their, quote, similar level of involvement bears fruit. It all depends on what similar level of involvement means, but given this example, very hard to see what my learned friend had in mind. Fourth, in paragraph 67, the claimants allege that their new regime results in fewer hits, and my learned friend repeated that in his oral submission moments ago. Now, on the one hand, they say that they've tested their revised keywords against a sample of 5 custodians, and this has produced a 36% reduction in the number of responsive documents. But what my learned friend hasn't explained, didn't explain it in his skeleton, HFW didn't explain it in their letter, and he hasn't explained it today, is how were these 5 custodians selected? Are they a representative sample, and if so, how? And why? He says there wasn't time to go beyond 5. Well, the last keywords hearing was some weeks ago, and it would be interesting to know how long these searches take and why it couldn't have been run against a higher sample. But in any event, we say there doesn't seem to be a sound basis, and there's certainly not a sound evidential basis, because this wasn't in the evidence, to make the submission that the specific 36% reduction should apply to the total figures generated by the consolidated keywords list when using the agreed terms and the claimant's proposals. So on the other hand, again, just focusing on fewer hits, if one accepts for the purposes of argument that the 36% reduction should be applied across the board, it's noticeable that it still leaves the claimants with a document population. Now, I had thought it was 300,000 documents, and I was about to make the submission that that's inordinately high. My learned friend has now said it's actually 360. Now, that's far too high as a starting point. My learned friend, and I'll come to his estimates about when the claimants think they might be able to complete their disclosure. But if you start at 360,000 documents, and I'll come to hard copy documents because my learned friend talked about various boxes, and what he means there is 135 boxes plus, but I'll come to that. But if you start with 360,000 documents, even if you apply filters and even if you apply keywords, you're still going to have, on balance, a very large universe of documents. And again, in my submission, the evidence on the review rate in Ms. Howard's witness statement, which is at paragraph 163, you'll see that at page 953 at the bundle, it's more realistic about what a reviewer can get through. And so my lord asked my learned friend, so what is your estimate? What's your timetable? When will things be done that lead to the 31st of December? We tried to set that out in our evidence. I did not see that in Mr. Braganza's evidence, and I did not hear from my learned friend what the step-by-step proposal is. Finally, paragraph 68 of my learned friend's skeleton. He states that the claimants consider that their new and improved regime will result in a significant reduction in the volume of documents, making the search realistic and crucially achievable in the time available. And then he goes on. The claimants would expect the same applied to the defendant's documents, and that's at 4.126 of the bundle. So let's take the former statement. Claimant's proposal makes the enterprise realistic and achievable. Now, it's doubtful whether that can be given any weight in circumstances where I've said, even if one accepts a 36% reduction applies across the board, and we don't have any basis to accept that as a proposition, your starting number is still 360,000 documents. And unlike the defendants, the claimants have not given any estimates of the steps that need to be taken till trial, even making assumptions in the best way that they can. And the latter statement is very surprising. The claimants would expect the same that would apply to the defendant's documents. It's difficult to see in my submission how any predictions can be made about how the claimant's proposals will affect the defendant's disclosure exercise when the defendants simply haven't run the numbers. Very difficult to see. So then there's some points that my learned friend made in his oral submissions today. So starting with some points that he made earlier on, he said when we were looking at the revised proposed timetable, he said that'll be difficult, the truncated timetable that your lordship was suggesting, because we won't be able to run the metrics in such a short period of time. But that actually misses a step in what we're asking the claimants to do. What my learned friend did in his skeleton was a radical reorganisation of what had gone before. He rewrote the landscape. What would happen in the proposal that I put forward, and if my lord makes an order to some effect that's similar, is there'll be a slight revision of what's going back and forth. It's not reasonable to expect the parties to reinvent the landscape. And so it's not a complete reorganisation. It's not an entire reinvention. It's just effectively revising what's there. So we say it can be done on the time. Now, my learned friend says, very concerned about the ceiling, very concerned it's going to take out some relevant documents. But we've got to be realistic. I mean, I, more than anyone, having spent many years at Oxford, love a bit of theory, but this is not a theoretical exercise. And my learned friend made the precise point. Theory doesn't matter here, it's practice. And when we're talking about practice, the numbers is what matters at the end. And we have to find a way, working together, to get that number down. And if my learned friend says, well, there's just some searches that are so important, defendants, you've got to do a search that results in 20,000 hits. I mean, that's just not going to be realistic in the time we have. There is a symbiotic relationship between the size of the search and the length of time it will take. If my learned friend wants bigger searches, it's going to take more time. We're trying to get to a deadline, that means less searches. It's just as simple as that. It doesn't get more complicated. Now, my learned friends that then said they've compiled the list. And they've compiled the list taking into account what they think the defendants would want or what they think the defendant's case is. That's unacceptable. I mean, it's very unusual in high-level commercial litigation for one party to have say on what the other party would or wouldn't want based on their own case theory. But there are problems, and I'll come to in a moment about date ranges. I mean, some of the date ranges that the claimants have applied are not the date ranges that the defendants would wish to apply. So from what we can tell, the claimants have compiled their list from just on our broad review using their preferred search terms, their date ranges, including various terms that haven't been mentioned like PB and private bank. And we say that's not an appropriate starting point. I mean, this process does need to be fair. So then my learned friend said at one point, the most important thing is to be fair to the defendants. I don't understand how that submission works with how this has been, how these events have unfolded. How is it fair to the defendants to have the claimant's terms foisted on them and to have an order to say you must conduct those searches when we haven't had a say? It's just very, very difficult for me to understand that submission. And another point that another point that I think is important is, and your lordship raised this, What happens if we live in the claimant's world? What happens if the order is made that the claimants are seeking? Well, what's going to happen, I would imagine, and I can't tell, and this is the point I'm making this based on hypothesis, is my clients have to apply the claimant's search terms. They've been devised by the claimants what they think will suit their case. They say they've taken the defendant's best interest into account, but we can't tell, and we're sceptical. So we apply them and the numbers are very high. What happens then? Well, my learned friend says we're not available till the 27th. I'm not sure. I understand that there's a third member of council on the claimant's team, and perhaps he's available before the 27th, because I'm certainly available before then and happy to make myself available. But the point being that I'm not quite sure what we're meant to do. We run the searches, the results are very high. We write to the claimants and say, well, in order to run these searches, here are the results, they're too high. Would you agree to this change? Would you agree to this different version? And I'm not sure what the claimants are then meant to do, because they have an order saying that the keywords list has been settled. If the answer is, well, the claimants should engage constructively and reasonably, because that's how international commercial litigation at a high level should work, then what you have is a de facto installation of the regime that I'm proposing. So again, I'm not sure, as a matter of practical reality, my learned friend's suggestions work. So my learned friend took you to page 4144 of the bundle. Can I ask you to please, 4144, yes, I think it's in his search terms.
This is the annex to.
Yes, it is. I'm very sorry, my lord. I work from paper and I couldn't print 4,000 odd pages. And so it may take me a little bit of time to find documents.
4144, you think?
4144, entry.
Yeah, which entry?
Sorry, 4146. Sorry, apologies. Entry 86. So my learned friend referred to entry 86 and talking about how, in the context of the submission about limiting searches, in the context of transfer, but every time there's
obviously a difficult word, transfer.
obviously a difficult word that needs to be worked through, but have a look at the breakdown of that search string. Every time there's a star, that's a wild card, which means you can change the ending, transferring, transferred. Every time there's an OR, there's a geometric multiplication. And so I haven't been able to go through, and nor have my clients been able to go through this list with a fine-tooth comb. But when my learned friend submits, don't worry, trust us, we've gone narrow. I've seen terms enough in the time that I've had to suggest that that cannot be taken at face value. Of course, the proof is in the pudding. We run the search and we see the figures. A learned friend says, can't do that, we haven't got the time. So take it on advisement. I've thought very hard about the theoretical underpinning of these particular entries and they work. So let's trust that it'll bring the figures down. We say that's not acceptable in a world where the biggest consideration is, can the parties meet the deadline and what's the best regime to meet the deadline? My learned friend made this submission. We think that these sorts of searches will generate a more proportionate approach to the sentiment that we want to capture. Well, again, capturing sentiment is obviously something in mind. It goes to relevance. It's important. And I won't say it's not. But in the end, I think we're in heated agreement that proportionality is the key question here. We're not arguing about relevance. We're arguing about proportionality. Although I agree with my learned friend, that's a question for subjective judgment. It's also a question you can't answer in a vacuum. And so when he says, well, don't worry, we've tried to capture the sentiment that's behind these terms, that simply won't cut it if we don't have the figures. Next, my learned friend made, and this is the agreed terms point, the very surprising submission. We've tried to retain agreed terms from the list that were not excessive, or they did not generate an unreasonable number of terms. Now, I won't take you to it because my lord is not that interested in history and wants to know about the way forward. But my instructors, after they received the revised list, wrote to my learned friend's instructing solicitors and said, we're having difficulty understanding this list. We need a comparative document. We need to see what's still in and what has been changed. The email said, we can't produce that for you. We'll get it to you whenever we can. We haven't received it. So in those circumstances, I certainly wasn't aware that any agreed terms had been cut. But to say that they've been cut by a subjective unilateral assessment as to what's excessive is concerning because, again, what's excessive in the claimant's view? How many numbers was deemed to be excessive? How many were deemed to be unreasonable? But the underlying point, I think, is that in my submission, is it suggests they've deleted some agreed terms. We say there's no justification for that unless they're saying there's a ceiling. If they're saying the reason why we deleted the agreed terms is implicitly they're above the ceiling, then that not only agrees with my proposals, but it actually is quite sensible, if that's what they're saying. But again, I'm not sure the basis for my learned friend's proposal on that, but I would say there is absolutely no principled basis for cutting out any agreed terms unless the parties have agreed a ceiling. So next, you asked about some more granular examples about where we think the claimants may have gone wrong, and I'm able to give my lord a few of them.
I don't think that's going to help me much, Mr. Conte.
Happy to move on. I'm more than happy to move on. So bear with me one moment, my lord. Hard copy documents, I think, is quite important. Can we please turn up the letter?
Sorry, what was that?
Hard copy documents.
Oh, hard copy, yeah.
So the letter that was sent, it was sent some point yesterday. I was sent multiple pieces of correspondence yesterday, some quite late, so I'm not sure what time it was sent. But if you could please turn up page 4454 of the bundle.
See if I can get that now.
You may not, this may be the one that you couldn't find, and if it is, it's fine. I'll just read from the letter.
Which date is that?
The 5th of November, 2024.
Way, I've got it. Yeah.
A victory for technology, my lord.
Well, I think all it was that Section L hadn't come through. You know, it takes time to come through, but it's there now. I've got 4454. Yeah.
I'm a dinosaur and I work from paper, so it's the one advantage. The paper documents always come through because you print them. So if you could turn up this letter. So I won't take you back to the previous statement, which was Mr. Braganza's 8th witness statement, but my learned friend, I think, admitted in his oral submissions that this doesn't take the position much further than where we were in May 2020. Yeah. But if we have a look at paragraph 5, so paragraph 4, the hard copy files consist of 212 boxes of files stored at CIBCO and 10 files held by the former liquidator. Then it's described about what they are. Then there's a statement that says the claimants will review the latter two categories of files. Paragraph 5, an outlining of what those hard copy documents are, a breakdown between things, for example, like accounts department files, HR files, regulatory compliance files. And then there's this paragraph at 6. As to the files stored by CIBO, the claimants propose to review 132 boxes as follows. All boxes from Compliance and Operations Department files, 6 boxes of the Accounts Department files, and 15 boxes of the HR Department files. Now, of the 132, they're proposing to review a sample. They haven't started reviewing a sample. We're not sure about whether that will lead to them to having to review more of those boxes. So it could be a lot more than those, and it could be up towards the top end of the 132. We just don't know. But if we move down to paragraph 7, our client's current position as to the review of these documents is set out in Braganza 8. So essentially what this says is they have not moved on from May of this year. That's when they last took a snapshot of where they were. I won't ask you to turn up the statement, but this is saying we haven't really done very much. And so when you asked my learned friend about their hard copy document review, he said, well, there are various boxes to be reviewed, but we just don't know what various means because they haven't started the review. We don't know whether the items in 6 will be sufficient. We don't know whether they've got to go through more of them. And there's still a process then of reviewing them, of scanning them, of working out how many need to be uploaded, of working out how we marshal them and how we apply CAL to them. And so I'll come in a moment when you asked my learned friend about steps to completion, but this is very opaque and it's very unsatisfactory. Now, fair it was that your lordship held my client's feet to the fire, and they have responded in the only way they know how, and with redoubled effort on every side, the clients themselves and their advisors. But my learned friend just hadn't explained why between May and last night at about 11 p.m. Dubai time, no progress was made on hard copy documents, nor has he explained where they're going to go from this. So it's entirely unclear to me how my learned friend can make the statement he makes in his skeleton where he says the claimants remain, quotes, well ahead of the defendants in the disclosure process. So I simply don't understand the basis for that submission. And it's also unclear to me how he can say that they're in a position to meet the 31 December deadline and they say this is achievable in the time available. I mean, especially when they say, and my learned friend made this submission, it's difficult to see how we'll get down to 50,000 documents to review. I mean, the evidence that my clients have filed give a breakdown of step by step to completion. My Lord has that. It's very clear what we say the steps will be and how long each will take. It's regrettable that claimants haven't done that because we don't understand what the estimates are, we don't understand what each step comprises, and we are particularly concerned about the hard copy document position. Now, let's assume, I mean, and we don't even know this, but in terms of the actual boxes, the 132 boxes, assuming that there were more papers to be reviewed, if you assume that there might be 2,500 pages per box, which I'm told is the norm, then there's over 300,000 pages there, 300,000 pages that might be reviewable. Sure, they can do a sample, but it's perfectly possible that the sample then denotes they need to conduct some more searches. How long will that take? How many reviewers will it be? How many tiers will be applied? We're in the dark about this. And so, again, my learned friends made several points in the skeleton, and so did Mr. Braganza in his statement, saying that my clients are dragging their feet. I think there's something about playing games or strategical positioning. Nothing of the sort. What we have is we've been very transparent, very clear about where we are, and I've given your lordship an update today. We haven't had the same from my learned friend. Now, my learned friend made an interesting proposal. What he said was, well, if you're against me on my view of the world, just approve the claimant's search terms for the claimant and let us get on with it. But I think it's not, I wouldn't have to work hard to persuade your lordship that legal processes should be fair. And if that's a proposal, then the defendants should set their own terms for their own documents and they should go away and apply those, because the essence of fairness is treating the parties equally. And if my learned friend's alternative argument is, well, let the parties set and mark their own homework, well, then parties should be in the plural. So if that's a proposal, then we should be allowed to go away and set our own terms. I don't think that's certainly not my proposal, but that's the logical conclusion of my learned friend's argument. So that was a very, very quick skip through, and I apologise if I've moved through at a pace, but with all due respect to my learned friend, I was very concerned about half a day to get through the agenda. My instructors wrote and asked on several occasions, are you sure half a day will be enough? And I was assured, we were assured in correspondence, half a day would be enough. And I'm still deeply concerned because we're 3 hours and 15 minutes in, and I just do not want to hold back my lord, nor do I want to hold back the court staff. So apologies if I'm taking these submissions rather quickly. If you would like me to slow down, please let me know. But that, my lord, is unfortunately the best I can do in the world in which we are now. So then I think where that leaves us is my alternative submissions or my alternative proposal. And for that, bear with me a moment. I think the best way to attack this is probably for you to turn up the draft order.
Yep.
2.5.
But just picking up on the last points that you've made.
Yes.
There isn't any reason why the claimants shouldn't get on with applying their own keywords to their documents, as long as you have the opportunity to add to that anything that you think is appropriate, or things that terms they're using that are inappropriate. It may turn out to be inefficient or a slight waste of time, but it may turn out to be hugely beneficial.
Well, we would take issue with some things immediately, like date ranges, but would then the idea be that we're afforded the same courtesy? When we're ready to go, we apply our own search terms and they
No,
can
no,
then...
no, 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 no. I'm just trying to think of ways in which this can move on faster, that's all.
If we're to move on, that my submission would be, it needs to be fair. Both parties need to be treated fairly. So if the claimants are allowed to apply their own search terms and they want to get on with it, then we should be allowed to apply our search terms to our own documents and we can get on with it when the time comes. But I'm afraid, and what I'm very concerned about is you'll just end up, my lord, I would have thought, with a range of correspondence going back and forth about each party has selected search terms that the other party just doesn't find palatable. And so the problem with let's just get on with it is that I don't think there's a workable solution. I think we probably do need a landing because of the way that this issue is unfolding. But the more fundamental problem is that I don't think on our side you can get a landing without the figures, and we haven't got the figures. I think that's the problem. The other problem is just saying to the claimants, well, you can get on with it now, is that we may have a very, very long list. We haven't had a chance to have a look at the proposals. And so I'm not sure what's served by my instructors sending a 20-page letter on Monday saying, we've had a good look at this, and actually, here are all the reasons why we think your search terms don't work for various reasons. And then I'm very unsure about what the status of the search is then. So the claimants say, actually, we disagree with everything you said in correspondence. We're running our searches. We're left there saying, we don't think they're right. And on my learned friend's availability, we're left in a hiatus till the 27th. I mean, I must say, it's a very long time to have to wait to sort this out. And when I started, I said, we are keen to get this sorted and I will make myself available as much as I can. And we have 3 potential counsel that can deal with this. And I think the claimants have the same. So if we need to move things around or someone else needs to do the next hearing, I would have thought that would be acceptable to make it happen because this is important. Now, in terms of my proposal, do you have the order in front of you, my lord?
I do.
So if we can start with the appendix. So the idea with the appendix and the idea with the general principles is, and I hear that whether a friend had concerns with a particular part of the proposal, but the idea is that this was not meant to be set in stone in terms of the consequences. So when it came to the reasonable exclusionary filters, it was more a starting point for us to try and agree what the principles were and then try and set the numbers. But the thinking behind it at an abstract level was apply reasonable filters, clear away the obviously irrelevant material. Because remember, if you feed irrelevant material into the CAL algorithm, it is going to have an effect on the ability of the algorithm to determine relevant from the irrelevant. Now, my learned friend and I don't quite agree about what that effect will be, but it will have an effect. And it is a matter of principle. If you have a more relevant test batch, you are going to get a better result. I think at one of the keywords meetings, one of my instructors described it as the garbage in, garbage out principle, and that's probably right. We're concerned about pollution, we're concerned about polluting the algorithm, and we think the application of exclusionary filters, at least on a preliminary basis, will work. Now, that's not to say that you apply them at the beginning and then if the parties don't think of others, they can't apply them down the line. But we think it makes sense to try and clear the terrain first. That's what it was trying to get at. And if there are nuances about the drafting that my learned friend takes issue with, we're happy to engage with those. But that's the general concept. But we think that it's very important to try and clear the terrain because we think it will remove irrelevant documents from the data set, help reduce the number of false positives in the data set, and as I said, it'll help ensuring that the CAL algorithm is properly trained. Paragraph 2 is a question about the floor. Now, the proposition is a very simple one. Parties pick a number. If the search term in aggregate, the number of hits falls below that threshold, it's a search term. Parties will search and they must be agreed. Purely pragmatic. That's the only reason why I suggested it at the hearing, at the disclosure meeting, and why we're pressing it today, is we're trying to get some principles that clear away some of the terrain. Now, obviously, to agree the number, it's going to again be a question of overall metrics, because if you are dealing with a floor and you call the floor 50, but that ends up in adding 10,000 documents, that's fine. But if you agree to a floor and it's 100 and that adds 100,000 documents, that's probably not going to be fine. But again, driven by the metrics which we don't have, but sensible in the abstract, we say, to try and clear away some of the terrain. And 3 was a ceiling. So my learned friend takes issue with the ceiling because he says, well, absolutely not. Some searches might be incredibly important and we need to have them run. This is suggested again, and I refer to this in our skeleton. It's suggested on a purely pragmatic basis for proportionality concerns. It is simply not going to be feasible to meet the current disclosure deadline if you have one hit or multiple hits, singular hits, that return 10, 15, 22,000 returns, which is what some of the hits in the original table were returning. It's just not going to work. And so the proposal was to try and limit this in some way by having a figure that we agree, hopefully we agree, but having a figure where we agree, thou shalt not go past this figure, purely to try and meet the deadline. Of course, the alternative is if you don't have that figure, you have more documents and you won't meet the deadline. But my learned friend cannot ride two horses. We cannot keep saying, review more, review more, review more, and get it done by the deadline. It doesn't work that way. There has to be a sacrifice of one thing for another. And the cases my learned friend cites, and I agree with the principle wholeheartedly, is that sometimes you must sacrifice perfect justice for pragmatism. That's what proportionality is about. And in a system with unlimited money and unlimited time, sure, every document, up to 22,000. Let's look at them all. Let's do disclosure for 3 years. But that's not where we are. And your lordship put our feet to the fire. We've been working to the 31st. We're still working to the 31st. But the reality is, if there's no ceiling and there are searches that return tens of thousands, even 5,000, 8,000, I'm not sure what the figure is, we need the metrics, but it's going to make it exceedingly difficult to meet the 31st of December deadline. Paragraph 4. The thinking here was very simple. When you're looking at between the floor and the ceiling, the parties have to work diligently to apply filters to try and get the numbers down. And I think we're agreed, hopefully, on what those filters are because the examples are taken from the evidence. So again, these are just simply principles and ways that we've tried to brainstorm that the parties can use some tools justified by pragmatism and proportionality to try and get the numbers down. Of course, if we produce the numbers and there's a principled basis why they won't work for whatever reason, then they can be revisited. We'd hope not, because they make sense in principle, but we have to find a way to narrow the terrain, we say. And we say principles of this nature will help. Although, as I say, my learned friend has issues with the particular consequences or the drafting, we can look at those. So then there was the proposal about timings. If your lordship would turn to page 4325. So how we had originally envisaged this happening was we had thought that effectively the defendants would send over the first shot and get the ball rolling on the 11th. Now, my learned friend and his instructing solicitors, as you say, have done a very detailed analysis of their position, of rewriting the terrain, and we thank them for that. We thank them for at least putting the position down on paper. We have that. I'm instructed that by the 11th we'll be able to run searches in full quite easily on relativity. And therefore we say on the 11th we can respond. Now, why I had proposed the timetable I had proposed, and you see the dates are in bold and yellow highlighting because we simply did not know whether they would be workable. But the idea is to have another round at this. The idea is to not have another meeting where people's memories may be quite different of the events. It's just simply give us an opportunity to review the words, give us an opportunity to put forward our position. The claimants can then assess, and then we work out where we are. We'll do it on an expedited timetable. One of our counsel will be available, whoever that need be, to attend a hearing before the 27th, if the claimants will make one of their counsel available, and we will get this done, and the time lost will be minimal. My learned friend says, well, the main benefit of his proposal is if you agree to his proposal today, you save 2 weeks, or you save a week and a half, or whatever it may be. But the question is that right, and is that worth it? Because if you save 2 weeks, but we start with 500,000 or 600,000 documents on the defendant's side, it's just not going. We either need to get that down, and you won't really have saved 2 weeks because we need to have a debate about how to get that number down, or we're forced to go through 600,000 documents, and we will not have any hope of reaching the deadline in time. And so I've heard all my learned friend's submissions. I've heard what he's had to say, and I thank him for his submissions. But my ultimate submission is quite simple. This exercise must be guided by the figures. It must be guided by a collaborative approach. We haven't had a chance to comment. We haven't got the figures. If my lord is minded to accept my proposal, it's fair. And I think in the end, the additional time is justified by the fact that you will get a smaller body of documents on both sides in the end. So I've been reminded that we've been going for another hour and a half, and so maybe now or quite shortly, perhaps it might be the transcribers are feeling weary again.
Are you done?
Unless my lord has something further for me on this point. I mean, I'm not quite sure where we are in the agenda because, again, I was assured we would run to the agenda order, and this was much ink was spilt in correspondence about what was in the agenda and the running order, and now I'm a bit at sea about where we are or what we're dealing with. But if the question is, am I done in relation to keywords? The answer is yes, indeed, I am, my lord.
Mr. Sampson, do you want to come back on all of this? I mean, I think I've got both parties' submissions pretty clearly, but if there's anything you want to respond in relation to this aspect, I think now is your chance, but make it brief.
I'll do it very quickly, Your Honour, thank you. I mean, my learned friend's big picture point was about fairness, and we agree with Your Honour that if Your Honour just directs us to use what we've identified as the sort of reasonable starting point, then there can be further scrutiny of the terms, there can be refinement. I mean, we say that applies to the defendants, and we would urge Your Honour to make the order in respect of all of the lists that we've produced. But at the end of the day, my client's concern is to comply with the deadline. And so if Your Honour isn't with me about the primary position, then the secondary position is that we should get on with it, and we'll engage with any proposals for additions that the defendants may have. On metrics, there is a great interest on the other side in metrics, but on the 17th of October, and this is at 3460, they wrote us a letter, and in paragraph 8.1.4, they said, "We fail to understand why it is imperative that the parties have the stated statistics available for the meeting. Some proposed searches will obviously result in several thousands of hits. There is no need for the parties to identify the exact number of hits. It's clear upon review that many proposed search terms are too broad. Conducting a hit count exercise will only result in the incurring of unnecessary cost and delay." Now, we thought it was important because it would guide the discussion. We've had the discussion, we've taken that on board, and we've tried to apply the fruits of that to the list that you have seen today, Your Honour. And on our side, we think that what's being proposed is just a way of not being able to comply with the deadline, because it will be a bit more time of discussion, bit more time spent on preparing for a hearing and argument, rather than just allowing the review team to work with an established list of keywords and getting on with the exercise. And ultimately, we're looking at trying to do the same thing, but from different angles. We want to find ways to reduce the pool of documents if that becomes necessary, based on how many are returned by the keywords. And our position on that is that you just have to get into the documents and look at them in order to find those ways. Now, on their proposal, it's just a framework for a discussion, so we just don't see how that can get us to the 31st of December. On the deletion of agreed terms, I'm afraid we have to come back to the second meeting, but at that second meeting, we explained that agreed terms, now, after running the numbers, it had become apparent that agreed terms were inappropriate. I'm not going to go to the evidence because I want to be brief, but on the defendant's proposals for Mr. Walia, for example, they suggested that we search for balance sheet. That produced 10,000 hits. They suggested Lakshman. That produced 88,000 hits. Leverage, 10,800 hits. So I'm afraid to say that we have to move away from what was agreed. I mean, we've tried to keep as much of it in as we can, but a lot of it was simply inappropriate. On private banking, that was an agreed, the sentiment of private banking was an agreed term. It's in, if you went to page 730 in the bundle, Your Honour would see that there was an agreed term for Mr. Cunningham, which said institutional or private and banking, and change or revise or update or replace. So the concept of searching documents for references to private banking isn't new. On the points my learned friend made about Mr. Philip and Mr. Eisler, our position is that they occupied the same kinds of roles sequentially in BSA, and then Mr. Eisler actually overlapped in that kind of role between the two entities, D5 and BSA. So he was in both camps. He could see what was going on in BSA and in asset management. And then Mr. Philip moved over, and he handled he was involved in the audit report that you've seen before from 2015 in relation to client onboarding, but he also maintained a foot in the BSA camp because he was the company secretary. So you say that really a mix of terms that go to the issues about what was going on in BSA and what was going on at asset management are appropriate for them. Yes, and then the final point that I need to make is simply that our biggest consideration is meeting the deadline. There is no application to change the deadline, and so the court today needs to weigh up the options and see what will get the parties there, or what's most likely to get the parties there. All these points about setting out a detailed timetable from now until the 31st of December are really aimed at testing whether or not that date is achievable. That's not really, I mean, I know Your Honour is a practical judge, but that's not really a question that's up for decision today, because Your Honour is not being asked to change the date. So really, the question for Your Honour is, well, what's the best way of trying to get the parties to that date? And we say that that's our proposal. And so Your Honour should order the lists that we have produced.
Thank you very much. What I'm going to do, I think, is to make a ruling on this aspect now. Then we'll take a short, well, actually, then I'll find out what else there is that has to be determined. And then, if necessary, we'll take a short break. Whilst I'm not anxious to go through the past history of this matter, nor to allocate responsibility for the parties being in the position where they are today, I can say this, that on the basis of the material before me, I'm not satisfied that the defendants have until recently been acting as they should. At the meetings that took place, they were undoubtedly hampered by the fact that they had not got as far with their own disclosure processes as had been hoped. The later delivery of a server in particular in Dubai will not have helped. And the end result is that there have been defaults, which mean that the whole process is delayed, so that uploading of the defendant's documents will not be achieved until the end of this week or thereabouts, or so it would appear. The deadline for disclosure remains the 31st December. Given all that, the fact is that the claimants produced as an attachment to their skeleton a new series of keyword search terms, which were different from those which had been the keyword search terms that had been produced in a 59-page list, and which had been the subject of discussion but no agreement at the meetings that had previously taken place, the last of which was the 24th of October. The new list produced is sufficiently different from the previous list that had been discussed for the defendants not to be in a position today to address me on points of detail, but only to address some general considerations. One of those considerations that was put forward was the fact that some of the agreed terms had been changed. It seems likely that they were changed for good reason, because of the number of hits that would result from their being used. The major problem is simply this, that if disclosure is to be conducted satisfactorily, one has to know the universe of documents to which the search terms are to be applied, and have some idea of the metrics involved in the use of particular search terms. The whole basis upon which electronic disclosure questionnaires are exchanged and the basis of orders made for disclosure is that the parties have investigated to the fullest possible extent what the effect will be of using any particular search terms and how reasonable and proportionate the results and how reasonable proportionate a search will be in terms of the results that are going to be forthcoming. There seems to me obvious sense in looking at different custodians and different categories of documents when one works out what are, in fact, the appropriate search terms to be used. And indeed, it may also be the case that deciding on the relevant floor, by which I mean floor as opposed to ceiling, is the appropriate one, will vary as between the particular custodians and the particular categories of documents because of their importance in the context of the case as a whole. The end result is that I don't consider that I can make an order today that simply says that the keyword searches to be employed are those which the claimants have put forward. They may turn out to be extremely sensible, and I've no reason to doubt that they have been put forward in good faith and on a reasonable basis. But there are undoubtedly questions of proportionality which arise here, and the sample upon which the keyword searches have been used cannot be said to be satisfactorily representative in order to determine that the end result of such a search on all the documents will give rise to a sensible and proportionate result. That must particularly be the case when those terms are to be applied to the defendant's documents as opposed to the sample of the claimant's documents to which they have so far been applied. So given that's where we are, the question is how best to advance matters with a view to keeping the deadline of the 31st December, at least so far as it can be seen that that might still be possible. It seems to me there's no reason at all why the claimants should not apply their own keywords to their own documents and get on with that. And use the teaching, use them to obtain the algorithms with CAL and the like. It may be that there will have to be some additional searching thereafter because the defendants say there are unsatisfactory elements in the keyword searches used, or additional searches have to be done on the evidence of the Mr. Vallet on the one side and the Ancura material on the other. It seems to me that there is no real downside in doing the education of the algorithm by stages. Obviously, it's better to have the largest possible universe of documents before the process begins. But if one has a sufficiently satisfactorily large number, then because it's an iterative process, the algorithm can be developed as more documents are added at a later stage. There are problems still in relation to hard copy documents on both sides of the fence. The Swiss documents have yet to be investigated, and that's not going to begin till next week. And the claimants' boxes of documents, it appears, have been largely unopened as yet. So where to go? As I've said, I see no basis upon which the claimants can't proceed along the lines they wish with their own documents, taking the risk that there will have to be further work done in response to what the defendants have to say in due course. Putting that point to one side, it seems to me that a timetable along the lines of what the defendants is suggesting makes the most sense, with a view to being as comprehensive as possible in dealing with the issues which will arise. Just taking Appendix 1 for the moment and the general principles, I'm not going to make any particular ruling in relation to that Appendix 1, but by and large it presents a sensible sequence for the parties to adopt. I think paragraph 1.3a is not satisfactory in suggesting that if a document is excluded by reason of it or a family member containing an excluded keyword or excluded email address, that document and all of its family members will be removed from the universe of documents, regardless of any other search terms that appear in the particular document or its family members. That does not seem to me to be right. It may very well be that in such a case, one would have to review the document to see exactly how material it is in the overall context. Apart from that, it makes sense for the parties to discuss floor and indeed potentially at least a ceiling. And as already indicated, they may be different for different custodians or different categories of documents. It would not be for me to determine such matters at this stage. As to timetabling, the position is this: the claimants have very sensibly produced a reduced list, albeit one that may have excluded some previously agreed terms, but that seems to me plainly the list which should be used as the starting point for further discussion, agreement, and if necessary, a ruling by this court. That document was provided with the claimant skeleton, and the defendants are agreeable to provide a response to that by 5 p.m. on the 11th of November, and that is the order that I will make in relation to that element. It seems to me that in the light of what Mr. Sampson has said about the need for metrics to be carried out and so on in relation to the proposals that come back from the defendants, that the 18th of November is an appropriate date for the claimants to revert on the search terms for both claimants and defendants' documents, and that I should set a hearing date which will be sufficiently far in advance, but one which the parties can do, which enables the parties to meet with a view to ironing out those problems and still being able to present to the court the areas of difference upon which the court could then rule. So that I would be anticipating a hearing on the 26th and 27th of November, setting aside those 2 days for hearings of 4 hours if need be, to deal with all outstanding questions of disclosure, with a view to finalization of all the outstanding issues that remain at that point. So between the 18th and the 26th, the parties can exchange letters as necessary, meet as necessary, and then produce a skeleton which will have to be available 24 hours in advance of the hearing on the 26th and 27th of November. By that stage, the whole position with regard to both electronic documents and hard copy documents should be plain, and there should be nothing remaining to be discussed beyond a ruling made on that date. We will still operate on the basis of the 31st December as a deadline. If by that stage it is apparent that it is not a realistic deadline, we will have to revisit it. If by that stage it is plain that the further steps in the timetable to trial are no longer practical, that too will have to be the subject of revisitation, which is why in part I've decided that we need to set aside 2 days in order to deal with all the issues which may arise. I think that's all I need to say for the moment. I'm happy to adjust that timetable if the parties find that it's a better one is agreeable to them. But that's.
Can I just make one point, just a factual point? You mentioned, thank you very much for the encouragement. Just one point to clarify. My instructors will be going to Switzerland this week, not the next week. You mentioned next week in the judgment, but it's actually this week.
Right, okay. I think I'd seen something in the evidence that suggested it was going to be later this week, but I thought you told me it was next, but never mind. I'm sure.
Week. Yes. Yes,
yeah, no, well, whichever it is, but thank you very much. Now, what in fact remains to be dealt with at this hearing today?
I'm very grateful, Your Honour. So the points that are outstanding are the court's approval of the use of predictive coding, which I think was implicit in the ruling you have just given.
It is indeed. Both parties agreed, and that should obviously take place.
We did have some proposals for the exchange of information in relation to methodologies, but in circumstances where the population is going to be set, I think those can't be dealt with today.
Well, what did you have in mind, Mr. Sampson?
Well, we've in the Ancora material, we set out the sort of the way in which we expect to sample the documents and then teach the algorithm. And I would expect something similar to come from the other side. And that needs the population to be set because the sample size will depend on how many documents there are in the reviewable population. And then the other element of it was to tell the parties to exchange information about how they were going to approach the drawing of the stumps bit of the review. So what would their proposed cutoff be for the relevance score on documents, and what sorts of tolerances are they proposing in relation to the illusion test, so that the parties have an idea of where they're heading.
Won't that all come up in the meeting that I'm envisaging happening following the exchanges that I've ordered?
Yes, that's the point I'm making. I don't think we shouldn't deal with it today.
I think all those points should be dealt with then, and where there are differences between the parties, then I will make a ruling on that towards the end of the month. But you can take it as read that I think all those matters should be very specifically the subject of discussion, with the parties' positions made quite clear. If necessary in skeletons, I'm not encouraging huge exchanges of correspondence, but I do want to know exactly what issues are outstanding and have to be determined when we get to the next hearing.
I'm grateful, Your Honour, and that's heard loud and clear. Then the third point on the agenda was the additional custodian that we wanted in.
Yes, well, I'll hear what Mr. Conte has to say, but I'm with you that he looks to me like a necessary party, but Mr. Conte must have a chance to say what he wants to say about him.
I'm grateful.
Not now, Mr. Conte. We'll see what else there's to discuss before you.
And then have a break. Yes, yeah, yes, my lord. Thank you. My only point was about the break because I feel for the transcriber at the moment. So,
Yeah. Well, I'm just trying to
myself.
ascertain the ambit of what else remains. That's all.
I thought Mr. Conte was gearing up there. Then we have an item on the supervision of the disclosure exercise that was originally aimed at Mr. Gribby, but also the third defendant. And in fact, I've in relation to the custodians, I'm so sorry, I've forgotten. We also had provision of information in relation to particular repositories, including Avalok and some other items. And you've seen from the draft order, I mean, what we're aiming at is witness statements, we think, which set out information that the parties have been talking about in correspondence and which we thought was coming, but hasn't yet come. So, Your Honour, I'm in your hands about.
So we've probably got another half hour to 3/4 of an hour to go, have we?
there's also one item left in item 6, which is most of it's fallen away, but a date by which the other side will produce their comments on the draft list of issues. That's the only issue that remains under 6.
That's very helpful.
All right. Well, let's take a 10-minute break now and see if we can deal with the rest of it in about half an hour or so after the break. Does that sound feasible?
Yes, you want to say back at, shall we say make it 12?
Back at yes, back on the hour. Very good. On the hour, please. Thank you very much.
My lord, thank you.
Yes, very good. All right. Well, would you like carry on, Mr. Sampson?
Well, I suggest that the running order then is custodians, repositories, and supervision of the exercise. Your Honour has given an indication on Mr. Michard, so perhaps I ought to allow Mr. Conte to address you on that.
Yes, very good. Mr. Conte.
Thank you, my lord. Thank you for giving the indication. Just as a starting point, ultimately, Mr. Michan was a deferred custodian, and it's unclear why, and this is just an observation, it's unclear why the claimants would have decided to unilaterally to defer him as a custodian if he was as critical as what they say he was. So we're just very unclear as to what the thinking was, given that they now say he's so critical to their case and to being added as a custodian. But we hear the indication that you've given, my lord. So all I really want to talk through are the implications of what would happen if you were to add him as a custodian, if I may.
Yeah.
So you'll see in the evidence, and in particular in Miss Howard's statement, that generally when you add a senior executive, it's around 100 to 150,000 documents.
Yeah.
And so we're dealing with someone who used to be the CEO, so it's probably going to be more around the 150 mark. And so if Mr. Michan is added, it'll increase the data set by 150,000, give or take. So even assuming you reduce those numbers by, say, 75% by applying appropriate filters, still might mean that the defendants are dealing with 25 to 37,500 documents. And if you're talking about Miss Howard's estimates about what a level 1 reviewers can do, i.e. 1,000 documents per week, 10 level 1 reviewers can do 1,000 documents per week. Just by adding him will increase the first level review by about 2.5 to 3 3/4 weeks. So it's just an indication of, by adding him, what that means in terms of review down the line. So that's the long-term picture. The short-term picture is this. If he is added as a custodian, we will not be able to marshal, process and upload his data to Relativity by Monday. So the discussions that will take place next week will not include his data. And I'm told that we can't be 100% sure that his data will be extracted for the week that we'll be having the hearing. And so the discussions that are to take place probably won't include Mr. Michan's materials. I'm also told, because of the nature of his role, a lot of those materials may largely be irrelevant, but we can't be sure. So they're just the points that I wish to make so that my lord has those in contemplation. We've heard the indication, but if an order is to be made, it's not for today, it's for another day. But just so the point is very clear, every time a custodian is added, if they're a senior executive or if they're an executive, these are the types of numbers that we're talking about. And there is obviously a knock-on effect to what that means, because each step of the process takes time: extracting, processing, uploading, and then review.
Well, I understand all of that, and you've put down your marker, Mr. Conte, but you'll have to do your best. It seems to me, as the Chief Executive Officer, he ought to have been included in the first place, and now has to be included. And we'll see what the knock-on effect of that is in due course. But you must do your best to comply with the orders that have been made, recognising that it's a very late start so far as he's concerned. Okay, so that's him.
I'm grateful, Your Honour. And then the second limb of this issue is the provision of information. And of course, that's why we...
On this point, sorry to cut across my learned friend, but actually there's a fair bit of common ground in the sense that we more take issue with particular features of the order rather than the principle of providing a lot of this information. So I just wonder whether it might be more efficient.
Well, would you like to tell me which bits you object to, so to speak? Is that the quickest way forward?
I think I'm in your, my learned friend's hand. It's just simply he doesn't need to make the case, and it might be more efficient for me to run through the order and just say which bits we have problems with, and then he can respond to that, because I'm conscious of the time.
Sure. Why don't you do that?
So bear with me one moment. If you can turn up the order.
Yeah.
So one category of information was the further information in respect of the fourth defendant's executive committee and the wider roles of the fourth defendant and fifth defendant's custodians. So we've agreed to provide that information, and of course we're happy to do so.
So that's 4.1 and 4.2.
No, so what we're talking about here is 4.2 and 5.2. Sorry, and 4.1, sorry, 4.1, 4.2 and 5.2.
Yes, exactly. So,
the only issues that we have, I mean, we have issues about some more general points about the order, but I'll come back to them, making some general points when we hit repositories. But just purely on the drafting of 4.1, sorry, of 4.2 and 5.2, we would just ask that there be some clarification around what corporate group means. We want that to be more specific so that we're sure that we're complying with the particular notion, whatever that would be. So that's one point, and that applies to both 4.2 and 5.2. The other point about 5.2 is about timing. So I'm told that the relevant date range, well, I can see the relevant date range is in 5.2, June 2012 and May 2016. But I understand that D5 was registered in August 2013, so the relevant period should probably start upon registration.
That's very helpful. Would it assist if I just come back on those points then?
Yeah. Please.
I mean, and I take it as read that my learned friend is not objecting to the proposal that this be done by witness statement, which is how it was done before.
Sorry, I do have it. I mean, that's one of the general points. So can we just park that for a moment, and I'll come back to the general form points.
Okay. Okay. Well, let's just deal with the detail then for the moment.
Fine.
Corporate group means what?
Well, we think that means the JSSH group and the BJSS group, to the extent that the defendants think those are different things. But my understanding of the structure is that JSSH holds BJSS, and then the BJSS companies sit under BJSS. My learned friend can tell us if that's wrong, but that's what we would say. And your honour has already ordered.
Are you interested in their roles in other subsidiaries?
Yes, well, we are, because we asked for the wider roles, and their involvement in other subsidiaries might be relevant. I mean, we think that there should just be full disclosure about what they were doing.
Okay.
So we say because that might inform what they were doing on the executive committee, Your Honour. So we say, so that's what we say about the corporate group. And of course, Your Honour has ordered custodians who sat on both the JSSH board and the BJSS board. So we think that both are relevant there. On the date range in 5.2, well, my learned friend is right about the date of incorporation, but of course the people that came to be involved in the fifth defendant predated the date of incorporation. So we think this should just cover the whole period that the disclosure exercise is looking at, because ultimately this is information that's geared towards understanding who is relevant for the disclosure. So an example of that would be, we know that Mr. Eisler was involved in BSA before June 2012, and then going through after June 2012, he became involved in discussions about incorporating asset management. So that's obviously something that was taking place before the incorporation.
Well, I don't know that it's going to help a lot, but I can't see it's going to make much difference to you, Mr. Conte, whether we're talking June 2012, August 2013. You're just going to describe their roles. So let's make it June 2012.
Well, it's a question about knowledge, my lord, I'm told. It's finding people with knowledge who can actually speak to that period. That's what's going to be the problem. And the information that my learned friend is referring to would probably fall under 4.1 or 4.2 anyway.
Well, it probably will, I agree. But again, I think it's a do your best. I mean, I know you're waiting for this chap to come back from wherever he's been, having a holiday or something. But
I wasn't sure what my learned friend's proposals were for limiting corporate groups. Sorry, he was making the submission, but what's the precise proposal for the wording? Sorry.
I think the question, Mr. Sampson, is whether you're looking at every subsidiary from the Bank Sarasin holding company downwards.
Well, that's what we thought we would get.
Yes. So it's going all the way back to the holding company and saying what is the wider role within the group underneath the holding company.
The concern about that is purely the scope of the exercise. I mean, that is going to be an incredibly broad exercise, and I'm told that is going to take some time to produce.
I find that slightly difficult to understand, Mr. Conte. Isn't it all question of where they're registered as directors, and I mean, I can't quite see that they will have a defined role in a company, executive position or directorship or whatever it may be.
But I understand it would extend to mandates as well, and so there is going to be a lot of searching, I'm told. And it's also quite a large family office as well, I'm told.
Your Honour, I mean, this was raised by the defendants in their comments on the disclosure list. They said that the terms should have regard to the wider roles of the employees or of the custodians. So they raised it. They told us to have regards to it. They ought to provide the information.
The proposal at that time was wider roles within the bank. That was the meaning behind the terminology used. And again, I mean, it's quite different. We weren't legislating for a statute, and this is a very different intellectual exercise, I would suggest.
Well, all we're interested at the end of the day is what part they may or may not have played in the events with which we're concerned. That's what we're ultimately concerned about, and the information is surely aimed at that, as to knowing who therefore might have some relevant information about it. I mean, I think the answer is as you say, this isn't a statute, but we want to know, broadly speaking, in relation to those custodians, what they were up to in the period. And you'll have to do your best with whatever corporate knowledge there is of their roles.
But in terms then of the precise drafting, what does that mean for the term corporate group then? I'm not quite sure what the proposal is in what's the change to the drafting.
Do you want to define it more closely, Mr. Sampson? Can you give a form of words that makes it quite clear beyond a doubt what's covered?
What if we said the subsidiaries of BJSS and JSSH? And I think we should sort of keep corporate group and just say brackets,
Namely,
yes, those two companies and their subsidiaries.
So namely BSS and JJSH and their subsidiaries.
Yes.
Yes.
okay, fine. All right.
So having now in terms of the repositories, in terms of some
What about the rest of paragraph 4 and 5?
Well, I just have a couple of general points, and then I can come back to the specific. I just want to make a few of the more generic points.
Well, perhaps I'm sorry to cut across, but perhaps I ought to make the points that we have on the repositories. The indication was into Mr. Michan. So perhaps Your Honour should hear from me first on repositories.
As I said, we're happy to provide the information in principle. So I'm not sure whether that's necessary, but if you want to make the submissions.
No, I'm sorry, Mr. Conte. I thought that was the provision of the information was an issue.
No. So the general points are about form, witness statement, date. I mean, the general points are form, and then it's points of detail. So there's no objection in principle to some of them. But there is one. I think it's paragraph 6, where we say, if we go through the order, I think the most efficient way might be for me to make my general points, and then we just go through the order. And if
Okay, right, well, let's do that.
in terms of the general points, so paragraphs 4 and 5 require the provision of a witness statement from Mr. Tourette and Mr. Swan, we say that's not appropriate for a couple of reasons. So the claimants seek the information in the statement because they say that's how matters were taken at the first CMC. But your lordship may recall that at the second CMC, the defendants asked for the liquidator to provide certain information in the form of a witness statement. And the claimant said that they thought it was more appropriate for the information to be provided in correspondence. That's what the parties agreed, and then your lordship took no objection. And we just say that the same approach should be provided here, should be followed here. And as you'll note, that was the form that we had included in our draft order, paragraphs 8 and 9, when we had sought information. On the other hand, some of the information that the claimants seek is very dated and goes back over a decade. So, for example, Mr. Tourette will not have personal knowledge of many of the matters to which he would be deposing. So in those circumstances, we say it's simply much more efficient for Jones Day to provide the information in correspondence, which is the way that the form of the orders that we had sought in our draft order, and the way that it was done following the last CMC. Second point is that in some cases, the information.
If he was to do that, Mr. Conte, would he be revealing the sources of his information?
If he was to make the witness statement.
If Jones Day were to write a letter,
Yes.
would they reveal the source of their information?
They would say generally, that's generally who informed them, yes. But I mean, again, it's kind of, they'd say the entity, but it wouldn't be in the nature of a witness statement saying X or Y informed me.
No, I understand.
The point being, it's a cobbling together. You have to go to various people.
Yeah.
And my understanding is that the claimants are interested in the information. That's what they want. We're happy to give it, and we're happy to give it in correspondence. And this is the approach I thought we had moved to when it came to these requests. And the cobbling together, I don't think, is an efficient process. I think it's much more easily done just by setting out, here is the information you want. Jones Day can compile it, and then they can send it over. The second point,
I have in mind, there's a difference between (5.1), I think, and the other information that's being sought.
Yes.
Do you see what I mean? 4.3, 4.4, 4.5 can all, it seems to me, be appropriately dealt with in a Jones Day letter. .1, because it goes to questions of fact about of documents, checking against the client list. Oh, it is only checking against the client list, isn't it?
Yes.
Right. So I misread that. Yeah. Okay, I've got you.
So that's my first point. My second point is, in some cases, the information sought may be historical and just simply may not be available. So
Yeah,
we
sure.
thought it may be worthwhile just having the introductory words insofar as it is available, because I want to be very clear that in some cases we simply may not be able to identify the information and produce it. And lastly, there's a timing point. Each of paragraphs 5 and 6 require a response by the 13th of November. And even leaving aside the fact of the keywords and keywords, disclosure, and all the different bits and pieces that are going on, the fact is that the defendants just may need some additional time in order to marshal all of this information. And so we would request that the deadline be 20 November rather than 13.
Okay.
So they're my general points. Perhaps it might make sense for my learned friend to respond to those, and then we can move to the specifics.
Okay. What do you say about witness statements and Jones Day, Mr. Sampson?
Your Honour, well, we say that these are all factual matters, and they were previously dealt with by witness statement from these two witnesses. And in particular, something like 4.3 is actually an update to a table that was exhibited to Mr. Tourette's previous statement. So if the information there, which was supported by a statement of truth, is being corrected, and we say that that should be supported by a new statement of truth. In addition, I mean, on 5.1, again, we think that that is a matter which was covered by the witness statement, and is an important matter because it goes to the availability of documents and the integrity of the disclosure exercise, and that may be an issue at trial. And so it is an area of fact which we think again ought to be checked carefully and supported by a statement of truth. And I mean, we haven't gone into the evidence because we're trying to shortcut this, but we've already seen in Ms. Howard's evidence that client files have been purged, and we think that's very important in this case. So we think that this ought to be dealt with quite seriously, and we therefore suggest a witness statement. On the timing, well, I hear what my learned friend says, but we've been given the runaround on this for a long time. The information in relation to the roles and the executive committee and the wider roles, for instance, we were talking about at the last hearing, and Your Honour envisaged that information would be provided by the first disclosure meeting, and we didn't get it. And that was on the 17th of October. So the defendants have had a lot of time, and it's not really clear to us why, and they keep promising that it's coming, but it hasn't arrived, and we keep asking for it, and we keep not getting it. So we've run out of patience on that, and we think, again, this is an area where the feet need to be held to the fire, and so they should get a week to produce this information.
Right, thank you. Witness statement for paragraph 4.3 and 5.1. Otherwise, everything can be Jones Day letter, and all to be done by the 13th of November, with liberty to apply if there's a real problem.
Thank you, my lord. So just moving on now to the first paragraph that presents an issue. Paragraph 4.4.
Yeah.
So the defendants, Jones Day, have said in correspondence on behalf of the defendants that there's no issue providing the information attached to Roman numerals 1, 2, and 3. There's no issue with that part. The issue is with the introductory words, a detailed breakdown of the types of information that Avaloq holds. The problem is how I'm instructed is that Avaloq is an extremely complicated banking system, and it has vast seas of information and data. It's just it's similar to an NHS database, but just on a completely different level. I'm also told that because the way the system is set up, it's on a need-to-know basis. So it's not a situation where one person goes in and has access to all the data. Each person has a different profile, and so they have particular privacy settings, and they can only access information that they need to access. So in those circumstances, it's just disproportionate, extremely difficult, time-consuming and disproportionate for someone to go in and spend the time to extract this information when essentially the detailed breakdown of the information is not what I think or in my submission is not what really lies at the heart of the claimant's request. What they really want is an explanation of the three matters searched. And so ultimately, we just don't think it's proportionate to be providing the detailed explanation. If it was narrowed to a different explanation that might be workable, fine, but not as broad as what that is set at now.
What lies behind this request, Mr. Sampson?
Well, I'm grateful for Milan and Friend's explanation of the position. I mean, I think we are interested in the information that's held on the database that would be relevant to the claim, and obviously we want to understand that all of that is being searched. So again, this is a point about the integrity of the exercise. So if I were to say, and Milan and Friend might be able to help us on this, if we were to say that it's information that would have been available to relationship managers, heads of division, so people like Mr. Sassoon, and Mr. Carton, I'm not quite sure exactly what sort of label he has within the organisation, Well, how about this? If we said company directors, because he did ultimately end up being a company director, then I think that covers the people who are in play in the case.
Right. So again, it's the information, the types of information that Avaloq holds and was available to relationship managers, company directors, and is that it?
And heads of division.
And heads of division.
To the extent that's any different.
How does that grab you, Mr. Codley?
I'm completely enthralled, my lord, but I'll need to take some instructions if that's okay.
All right. Well, we'll come back to it then.
Just 2 minutes, if that's okay. Sorry, just 2 minutes.
Well, all right. Well, is there anything else on paragraph, the other paragraphs on provision of information detail points you want to raise? Because it may just, again, require taking of instructions if there's some nuance or variation.
My lord, thank you. I'm told the data will still be quite voluminous given the files that it will probably produce. The suggestion is that maybe we could write in correspondence and set out a proposal, because we'll have to go back and think about it and suggest a form of words very, very shortly, but it would need some further investigation, I'm told, about how to get it to a manageable description.
Your Honor, if I may, that we're not particularly enthralled by that, because that sounds as though the information isn't going to be coming, and ultimately this is all about resolving the issues on the disclosure exercise. So we think we need the information sooner rather than later, and all we're asking for are categories of information, not the information itself.
Well, I realise that.
The problem, my lord, on top is there are thousands of categories. It's not us trying to be difficult. It's just we're managing a database, a universe of really incredible size, And so describing it correctly is quite important. It would be completely disproportionate to have someone spend copious amounts of hours going through and trawling documents when they're just not going to be much use to the claimants. And so it's a situation where if we describe it correctly, we can comply. If it's described and it's incorrect, we're unlikely to be able to comply within the time frame at least, and then it'll just be the liberty to apply provision and we'll be back before you.
I'm struggling with the difficulty of this, Mr. Conte. The types of information that it holds. I mean, that shouldn't be too difficult to deal with, should it?
I'm told that the way that it's set up is when you log into the system, there are fields and there are thousands and thousands, and you have to go through them, and that's a manual exercise that takes a lot of time. I should say I haven't actually seen the system. It's not something that I can describe to you from actual personal knowledge, but I am told the interface is difficult. There are thousands of fields and you need to manually navigate them.
It's not intuitive or self-descriptive.
And it's not a particularly intuitive database.
How much progress have you made on this request that I think has been outstanding for a while?
But can I just take some instructions for a moment, if that's okay, my lord? So, my lord, I'm told that my instructors have spent a day with Avaloq going through all the categories and extracted some that they might think would be helpful. But the information is not in a way that at the moment can just be sent over. They need to be described. So it really is a step where, and it was a full day, I'm told, of interrogating the system, but it needs the actual list of categories would need to be drafted and described and then sent over.
Well, this is all about the integrity of the disclosure process. So, I mean, at the end of the day, you know, Jones Day need to satisfy themselves that they're getting this right. I mean, I just think you should get on with it, and if further questions arise out of what you've said, then they'll have to be pursued.
So when you say get on with this, my lord, are you suggesting with the current phraseology? Because we could change.
Well, we could take out the word detailed if that's what's troubling you.
If we put reasonable breakdown in Jones Day's view or something to that nature, so that then Jones Day have the ability to make a subjective judgment about the categories, which then they will bring down to an appropriate number.
Well, I think we just put a breakdown, and you can give the information, and if Mr. Sampson thinks that's inadequate, he'll have to come back on it. As I say, it's a question of the integrity of the process, and Jones Day need to satisfy themselves. But at the end of the day, the exact terminology here doesn't really matter, I think. So it'll be just a breakdown, full stop. not full stop, but a breakdown of the types of information.
Thank you, my lord. So moving on to paragraph 5 of the order.
Yeah.
So the parties have addressed this in correspondence. Sorry, we're dealing with I think it's 5.1 we're dealing with here. 5.1. Right. The parties have addressed it in this in correspondence. I won't take you to it. I'll just give you the upshot, really. I'm instructed that there's no way of the defendants verifying the data that previously existed but has been purged because there's no specific list of deleted items. The only way of being able to ascertain whether a document has been purged is if the 5th defendant shared that document with the 4th defendant before it was deleted. So Jones Day are of the view that the 5th defendant may have some shared client-related documents. Sorry, the 5th defendant may have shared some client-related documents with the 4th defendant, such that in regards to those documents, the defendants may be able to check whether the relevant document against the client lists. So it's very difficult for anyone really to provide the information sought, just because of this practical difficulty of there is no list of the documents that were originally deleted.
Understood. Well, that's a very good reason why Mr. Tourette should cover that in a witness statement. You can say whatever has to be said about it.
Mr. Swan, that is.
Oh, is it? Oh, sorry, it's Mr. Swan in this case. Yes, quite right. Yeah. Thank you. Yeah.
So you're on that basis. I think you're suggesting that the drafting should stay as it is.
It is, yes, absolutely. Yeah. Stay as it is. Mr. Swan will have to say what he can say.
Yes, and we agree with that. And obviously, if it's not possible, then that's relevant, and we ought to be told that.
Yeah, well, he'll say that. Yeah.
Thank you, my lord. So just the last point is paragraph 6.
Yes.
Again, this has already been dealt with in correspondence. I think we can take this quite briefly. The short point is that in relation, so Jones Day have explained in correspondence that the 5th defendant is willing to provide any instruction or exemption lists falling within the scope of that order, but they're only willing to do so subject to a suitable confidentiality ring. So that is the first category, and the third category, the instructions and exceptions list. When it comes to Mr. Gribby's email...
You'll have to forgive me, but I have no recollection of what it is we're talking about. What was Miss Bourguignon's email of the 1st of February 2023 about?
My understanding is these were email instructions in relation to a purge, the purge that was to be undertaken.
Right. Okay.
Purge exception, rather. Sorry, I thank you very much. It's about which documents were to be excluded from particular purges that were going on. Sorry.
Got it. I see.
So
yeah.
The point is that in relation to the instructions and the exceptions, happy to provide them, but we are restrained and can only do so subject to a suitable confidentiality ring. When it comes to Mr. Gribby's email dated 9 January 2024, that particular document or the attachment to that email, which is what my learned friend's interested in, is subject to Swiss restrictions. So the 5th defendant can't provide it, but the 4th defendant may be able to provide a copy of the document. But again, we would ask that. Sorry, bear with me. I may have made an error. If I can have a moment, I may have to correct myself there. Sorry.
I think you meant the other way around, probably.
So I'm told that the 5th defendant can provide what it provided to the 4th defendant, but it then doesn't know what the 4th defendant. So the point is subject to appropriate confidentiality restrictions and only what the 5th defendant is able to provide.
Right. And so far as the confidentiality point is concerned, what is the confidentiality element in this beyond anything else that arises here?
Again, bear with me one moment, my lord. I'm told that there's a concern because the information relates to client data and the sensitivity of the information, that is extreme reluctance to be discussing it in open correspondence. And so it would be advisable, or at least more appropriate, for it to be done subject to a confidentiality ring.
Well, would the simple answer be, in the first place, for it to be disclosed only to the lawyers acting for the claimants, and if there's any further issue that arises beyond that which requires wider disclosure or wider use, then that can then be the subject of further debate. But confidentiality ring restricted to lawyers for the moment.
Can I take some instructions, my lord? Sorry, one moment.
Yeah, well, if you want to limit it to very specific lawyers, I suppose you can, but it doesn't seem to me to be very necessary.
So I'm told that's fine. Limited to just the council team and the solicitor instructed in the matter.
Yeah. Okay, and we'll deal with any further issues as and when necessary.
Your Honour, can I just say something on that? Because I think there was a previous arrangement in relation to confidentiality.
I mean, right,
we don't say that. I mean, I think our primary position is it's not really necessary because it's protected by the collateral undertaking, we would say, because it's been disclosed for the purposes of litigation. But anyway, there was a confidentiality provision attached to your order following the first case management conference. Bear with me while I just find the...
I'm afraid I'd forgotten that completely.
So the order should be at 46 in the bundle.
All right.
And I'm only taking us there because I think we need not reinvent the wheel.
Yeah. 46.
That's the order, and then that was your case management order at the first CMC, and then there's an appendix to it at 436.
Apologies, I've lost the page. Can you tell me which page?
So the order is 426, and then the appendix to the order is 436.
Thank you, 436. Thank you.
And so we have here a regime that applies to defined documents called restricted documents and of authorized persons.
Yes. Oh, well, that's authorized persons are very specifically named. Yeah, well, that would satisfy you, Mr. Conte. It's then going to go in accordance with that appendix.
That should be fine. Yes, my lord.
Very good.
And
all right.
Just to draw to Mr. Conte's attention, Roman 9, which is sort of secretarial and support staff.
You.
I hope he doesn't object to that.
No, it's one of the few things on which we can agree.
Right. Yeah.
So I know this is a separate point, and my learned friend can make his submissions because this is about paragraph 7. And again, I'm happy for my learned friend to go first, but it might be more efficient if I go first on paragraph 7 in relation to the third defendant.
Mr. Carson, yes.
So the order's there before you about what it seeks in particular, and we can do away with 7.2 and 7.3 because I can provide an update now. In Mr. Vallett's paragraph 8 of his witness statement, he said that EY was prepared to assist with the extraction of potentially relevant documents from the third defendant's personal Gmail email account on Monday, the 4th of November. And I'm instructed that EY captured the data in that account on the 4th of November. So the confirmation I can give now that 7.2 and 7.3 have been done by EY, which was one of the claimant's concerns. And then that only leaves in paragraph 7.1, and position on that is that it's been dealt with in correspondence, and my position is we've given the responses that I think should satisfy my learned friend. So there's the letter dated 7 October 2024, where HFW asked Jones Day questions about D3's document retention practices. So that's at 3436 of the bundle. So this is paragraph 26. And Second line, please clarify whether the third defendant has a practice of retaining or deleting emails in his personal Gmail account at any time since March 2013, when he was employed by the fourth defendant. If so, please explain whether the third defendant retained or deleted professional emails that were sent to or from his Gmail account. So what's important to note about that request is fairly, given the question required the third defendant to confirm matters occurring over the last 11 years, it was limited to whether the third defendant had a practice of retaining or deleting emails. It did not specifically ask him to confirm whether he deleted a single email on a single occasion in the past 11-year period. And then the second question was limited to asking about whether the third defendant did or did not, what he did or did not do in relation to professional emails. So Jones Day provided the information requested in their letter dated 17 October 2024, and that appears at 3468 of the bundle. So 10.21 is a relevant paragraph. In paragraph 26 of your third letter, you asked two questions regarding Mr. Carton's document retention policies. We reply as follows. Since 2013, Mr. Carton's usual practice has been to retain the emails sent to or from his personal Gmail account. We've provided you with evidence that this was Mr. Carton's practice. For example, on the 17th of June 2024, we provided you with an inline forward of the relaunch plan email from Mr. Carton's Gmail account. The heading of that email demonstrates that it was forwarded to Ms. Martin of Jones Day on 5 January 2024. This shows that Mr. Carton retained the relevant email after receiving both the LBA and the claim documents. Next paragraph, Mr. Carton also retained professional emails that were sent to him, that were sent to or from his Gmail account in the relevant period. And so Jones Day have confirmed that since 2013, the third defendant's usual practice has been to retain the emails sent to and from his personal email account. Thus, if his usual practice was to retain the emails sent to or from that account, it necessarily means that, in line with his usual practice, he likely would not have deleted any emails sent from or received to that account relating to the business or clients of the first defendant, fourth defendant, fifth defendant. That is, the response that Jones Day gave here on his behalf covers the field. So, and finally, the key difference between the question that HFW asked previously and the form of this order is the order asks the third defendant to confirm whether he deleted any relevant email at all. And in my submission, it's not reasonable to ask the third defendant to confirm that, as the relevant period spans over 11 years. So it's reasonable that he may not remember deleting a single email on a single occasion. And I'm instructed that the third defendant is quite elderly, so his memory in particular may not serve him as well as someone who's younger.
Well, yes. All right. What do you say, Mr. Sampson?
Well, the big picture point is that this is again about the integrity of the disclosure exercise, and we've seen what's said on Mr. Carton's behalf in relation to a general practice. As my learned friend says, that likely means he did not delete emails. That's the sort of inference that we're invited to draw from the letter. But we're concerned because we've learned from Ms. Howard's evidence file for this hearing that no document preservation notice has been sent to Mr. Carton at all, even now. And so his documents have been left unprotected, and obviously we were also concerned by the fact that they weren't within the scope of EY's exercise, and we've learned now that they are. So they've sort of been sitting there with Mr. Carton not having been advised to protect them. So that's why we say there ought to be evidence from him supported by a statement of truth about what has happened. Now, I take the point about the period. So I would propose to restrict it by reference to when Mr. Carton was first contacted by the liquidator in connection with his investigation, because Mr. Carton attended an interview with Mr. Hyder in London, and we'd have to go back and check the date for that, but I believe it would have been sometime in the request might have been late 2019 or early 2020. My recollection is that the interview took place in around March 2020.
But it is your point that you want this from the horse's mouth so that he could be cross-examined should he appear in court as a witness?
Well, yes, that's obviously where we are going with this. If there has been data deletion, then that will be a matter that will be canvassed at trial, and we would want to know what Mr. Carton's position on that is. And if he is elderly and liable to forget, then we should draw the line on it now. And I don't want to be unreasonable, so I'm proposing that it's limited to the period in which he was aware that the liquidator was interested in his role in the affairs of the company.
I certainly didn't understand that that was my learned friend's position, and what he was particularly interested in. I'm not sure whether he has a reasonable basis to have those suspicions. When we come to Mr. Gribby, I'm also not sure about whether this order can be made under the provision that my learned friend cites. I'm not sure whether this is what 2814 is actually on about. So the jurisdiction point I will make in relation to Mr. Gribby possibly applies here. But in any event, we've moved very far away from where we were in the actual request that I thought my learned friend was making. I mean, what I'd understood the request to be was a follow-up to the request that perhaps they might have missed, and the information's been provided. Now it seems like a very specific request based about a suspicion about deleting documents following an interview. We're just in a very different world, and I very, very much doubt whether there's a basis for that, but we'd want to see that basis set out because it's quite a serious allegation.
Your Honour, perhaps it makes sense to hear what I've got to say about Mr. Gribby, and then we can come back to this.
All right.
So if I may, I'll address the court on that, and then I think that will deal with paragraph 10 of the order as well. So the sort of point of departure, I'll take as a point of departure Jones Day's letter of the 17th of October, which suggested a sort of hypothetical that Mr. Gribby may be providing instructions to custodians. That was in response to our question whether he was involved in the strategy, operation or supervision of the disclosure exercise. And then what we got back was
I'm terribly sorry, Mr. Sampson. I've lost track of which particular order, part of the order you're directing these submissions to.
Well, this is paragraph 10, but so I'm so sorry, not paragraph 10, paragraph 8.
8, right, okay. Yes, okay, yeah.
But we say it informs the approach on paragraph 7. So Jones Day, we asked Jones Day about Mr. Gribby's involvement in the strategy, operational supervision of the disclosure exercise of the defendants. And we were told in response that if Mr. Gribby were providing instructions to custodians, that would be appropriate because Jones Day would have asked him to do that. And so that rather raised our suspicions, I'm afraid to say, because we didn't ask the question, and it seemed as though Jones Day were trying to sort of fly something under the radar in correspondence. So we asked the question, well, is he doing that? And the answer that we keep getting back is that Jones Day are giving instructions to custodians in relation to the disclosure review. But that doesn't answer the question, because the question isn't, are Jones Day doing it? The question is Mr. Gribby doing it? And they have not answered that question, which means that they haven't denied it. So here we are. We think that there's an issue. Now, this issue was ventilated before you at the first CMC in relation to Mr. Astruc. And if I can take you to the guidance that you gave on that occasion, which is at 2594. And if I ask Your Honour to read the second paragraph of what you said there, and just going over the page.
Yeah.
So the guidance that you gave was that there ought to be somebody independent and who takes responsibility for decisions within the fourth and fifth defendants, as well as on the part of Jones Day. So the supervision of the exercise is does not only come from Jones Day, but it comes from within the defendants as well. And so on that basis, Mr. Astruc was not permitted to supervise the strategic questions. Now, we say that that guidance applies equally to Mr. Gribby, and it hasn't been applied, it seems, by the defendants. And the reason we say that is because if we go to 59 in the bundle, 58 actually, if we go to 58, this is the amended consolidated particulars of claim, and paragraph 135 sets out the claimant's case in dishonest assistance against Mr. Sassoon and the fourth defendant. And if we then scroll down to subpara 7, we set out the allegation that we make against Mr. Gribby, and it's an allegation of dishonesty.
Yeah.
And it's dishonesty, and it's also, we say, falsifying the record at the time. And I do want to show you the evidence on it. It's very brief. So at 3924, there is an email chain. And if we work from the bottom up, so we have to go to the next page. And at the top, Mr. Nair of BSA provides to Mr. Phillip the draft financial statement for BSAME. And this has come from Deloitte. We can see that from the next email up. And Mr. Phillip, on the 2nd of July 2015, sends it to Mr. Gribby. So at this point, Mr. Phillip is the compliance officer in D5, but he was the compliance officer at BSA, and he was also the company secretary until its liquidation. So he's in both camps at this time. And he says, "Hi, Patrick, any comments?" "I do not have any comments." And then we get Mr. Gribby sending his comments. And we can see those. And in fact, it's relevant to note that he says, "See attached pages with comments." I assumed I had a Word version, it was only PDF. So he had to make manuscript annotations to a PDF. And then if we go to 3927, around the middle of the page, Your Honour can read that, but Your Honour will see the point that we picked up in the particulars of claim.
Yeah.
So Deloitte produced something which, and obviously they would have done this on instructions, that management had decided to transfer the book of business and employ it to other group affiliates. Mr. Phillip looked at that and said he didn't have any comments at a time when he was in both camps. So we say that that rather suggests that the characterization was accurate and Mr. Phillip accepted it. Mr. Gribby then looked at it and didn't like the look of that and made a change, which wasn't a typographical change. It was a complete recharacterization of what had happened in the company. And so for that reason, we say that this is falsification of the record in order to hide what had happened within the company, i.e. that there had been a transfer of the book of business. And that's obviously the subject of the claim. It's what we say exactly happened. So we then say that there are 4 points why Mr. Gribby can't give independent supervision of the disclosure exercise in this case. First, he's likely to be a witness because he's going to have to depose to this issue. The nature of the allegation, secondly, the nature of the allegation relates to interference with the company's records. Thirdly, it does appear to us that Mr. Gribby has control of the disclosure exercise. There is an EY engagement letter at 1595, and it's addressed to Mr. Gribby in relation to the e-discovery services that EY are providing. And Mr. Tourette's evidence is that they give instructions together. So Mr. Gribby is plainly involved. And fourth, and this is where D3 comes into it, D3's so Mr. Carton, his personal emails have been left vulnerable to deletion because they hadn't been collected in by EY. It doesn't appear to us that they've been segregated in any other way, and there's no litigation hold in place. And the third defendant has hitherto been treated as a custodian of the fifth defendant. The lists that get produced that relate to the Gmail account have always identified Mr. Carton and that account as a custodian or repository of the fifth defendant. So the fifth defendant obviously considered that Mr. Carton is sort of within its sphere of influence, and in any event, they're all being represented together, they're running the same defense, so we know that they're coordinating with one another. So the upshot of that is that we asked the court to give some guidance on Mr. Gribby's involvement in light of what was said about Mr. Astruc and what's been shown to you now. And we say that Mr. Gribby should explain whether he's been communicating with the defendant's custodians in relation to the deletion of data. And relatedly, we say that the third defendant should provide a witness statement in relation to the integrity of his Gmail account. Now, the last point that I need to tick off is the jurisdictional point that my learned friend raised. And this is old ground because it was addressed at the first CMC. So if we go to 2967, this is Mr. Shivji's skeleton argument and Mr. Sharafi's skeleton argument for that hearing. And paragraph 14, I just invite you to look at the last sentence of paragraph 14, Your Honour, and the footnote. And that is the approach that the court has taken hitherto. I mean, that's why we have the statement from Mr. Swan explaining about the purge exercise. So we say that the court clearly has jurisdiction. It's exercised it before, and it should do so again.
Yes. What was the date of the letter which Jones Day wrote in relation to the third defendant's emails? It was the one that Mr. Conte referred me to.
Yes, I think that was the 17th of October. Mr. Conte probably has it at his fingertips, but I can, if you bear with me, Your Honour, I'll just find it.
Thank you.
Yes, 17th of October, that's right. Yes, that's right.
Which number? Page number in the bundle?
At 3467 is the letter. And then in fact, that's the...
3468.
I'm sorry, that's Mr. Gribby. That deals with Mr. Gribby. I'm so sorry.
3468 is Mr. Carton, 10.21 paragraph.
That's the one, yeah. That's the one. Thank you.
Great.
Thank you.
Minute, friend.
And the date of the third letter that's referred to in paragraph 1021. Presumably that appears at the beginning of the letter somewhere.
It does, and I think it's the 7th of October, but I'd better just check.
It is, yeah, 7th of October.
7th of October, yes.
Right. This is a case where the claimants have substantial suspicion about the...
I haven't had a chance to come back on Mr. Gribby.
Oh, right, I was going to deal with... yeah, all right, you're quite right. You talk about Mr. Gribby. I was going to deal with this one first, but go on, yeah.
Sorry, it's just the jurisdiction point that I'm about to make in relation to Mr. Gribby may apply also in relation to Mr. Carton, and I raised it in that context. So I just, I may, but I'm happy for you to deal with it now. I thought you were going to deal with Mr. Gribby, but if you're going to deal with Mr. Carton,
No. Well, if you've got a jurisdiction point, you better make it.
So you start with the order in paragraph 8 of my learned friend's order. And my submission, it's an extraordinary order to be making. Essentially, the order seeks to compel Mr. Gribby to provide the stated information, effectively based on a presumption that he might be tampering with the disclosure process in some way, going behind Jones Day's backs, and or encouraging custodians to delete or withhold information. We say for at least 5 reasons, there's no proper basis for the claimants to seek or obtain what is essentially an extraordinary form of order. So even if there was some basis to support the making of the order, it cannot be made under RDC 28.14, the provision upon which the claimants purportedly rely. Now, I know my learned friend took you to a case, but I see that's an English case and that's a general proposition. And the order doesn't say generally, it says pursuant to RDC 28.14. Would my lord please turn that up?
Yeah, I got it.
So, para 2810, the parties should, so the heading is entitled Cooperation Between the Parties.
Yes.
2810, the parties should, prior to the first case management conference, discuss any issues that may arise regarding the searches for and the preservation of electronic documents. This may involve the parties seeking and providing information about the categories of electronic documents within their control, the computer systems, electronic devices and media on which any relevant documents may be held, the storage systems maintained by the parties, their document retention policies, and the anticipated time and cost of carrying out any searches which might be requested. 28.11, Where the number or volume of documents to be searched is likely to be extensive, the parties should, where possible, seek to exchange preliminary production requests in draft form before standard production of documents takes place. Moving to 28.12, the parties should cooperate in an early stage as to the format in which electronic documents are to be provided on production of documents. Then if we skip down to 28.14, which is the provision upon which my learned friend bases his application, in the case of difficulty or disagreement on any of the matters referred to at RDC 28.10 to 28.13 above, the matter should be referred to a judge for directions at the earliest practical date, if possible, the first CMC. So what RDC 28.14 is in fact concerned with is cases where the parties run into a difficulty or disagreement, where they are discussing any issues that may arise regarding searches for and the preservation of electronic documents, with a particular emphasis on cases where the parties are exchanging information on various matters, where the parties are dealing with an extensive number or an extensive volume of documents to be searched, or where the parties are discussing the format in which electronic copy documents are to be exchanged. In my submission, the short point is that these situations, again read in light of the heading cooperation between the parties, are a world away from the order that my learned friend seeks, which is essentially an order seeking to disprove or prove the claimant's hypothesis that Mr. Gribby was somehow tampering with the defendant's disclosure process. Put differently, the order has nothing to do with a failed attempt at, quotes, cooperation by the parties. So my first submission is if the claimants really do want to seek such an order, they should find another legal basis upon which to mount it and then make an application with the attendant costs exposure if they lose. Second point is this. The claimants seek to place much emphasis on the fact that they've accused Mr. Gribby of dishonesty in altering a draft order report. And my learned friend took you to the allegation in the pleading. Now, unfortunately, the allegation of dishonesty, there's two aspects to it that are problematic. But one of them is it's circular reasoning. So the only allegation that the claimants make in the whole of their consolidated particulars of claim is the one that my learned friend took you to. It's that Mr. Gribby proposed an amendment that should be made to an audit report. So the claimants start from the premise that the defendants put in place an unlawful scheme in order to deprive the first claimant of its business. Then they assume that such a scheme existed and they infer that Mr. Gribby was aware of an unlawful transfer of clients to the fifth defendant and that he deliberately sought to conceal this fact in the audit report. But that allegation only works if one assumes the very thing that they're trying to prove, that is, that a scheme existed. And so in our view, the allegation is circular. What Mr. Gribby was trying to do was simply correct a factually incorrect statement in the audit report. The audit report wrongly stated that the first claimant's business was to be transferred. Mr. Gribby corrected that entry to state that the first claimant's business was being discontinued. But in any event, as matters stand now, all the claimants have is an allegation against Mr. Gribby. There is no court finding to that effect. So the claimant simply cannot rely on an unproven, and we say baseless, allegation to strengthen a further different type of dishonesty allegation. That is, that Mr. Gribby would interfere with the disclosure process. We say that mode of reasoning is just simply impermissible. My third point is this. The claimants assert that Mr. Gribby appears to have control over the fourth and fifth defendants' exercise on the basis that EY's engagement letter for D4 was addressed to Mr. Gribby only, and that's in the bundle at 1595. Now, it's unfortunate, but the inference that the claimants seek to draw is a bad one because a relevant letter included in the bundle contained an error. And in particular, I'm instructed as follows. When the fourth defendant originally sought to instruct EY did not ask the fourth defendant or Jones Day about the person to whom they should address the letter. EY simply prepared the engagement letter with Mr. Gribby on the heading, as was their usual, signed it in accordance with their usual practice, and then sent it to the fourth defendant. In fact, the letter should have been addressed to Mr. Tourette, and the fourth defendant then contacted EY, and EY corrected the error. Unfortunately, due to an administrative error on Jones Day's part, they included the wrong document in the exhibit to Howard 3. However, the correct engagement letter is addressed to Mr. Tourette, and I think that is in the bundle now.
4438.
So I can give you the reference in a moment. 4438 is the actual version. It's the actual version to Mr. Tourette. So in these circumstances, what is effectively an erroneous draft document cannot aid the claimant's case on point. Now, my learned friend in his skeleton and also in his oral submission sought to rely on the fact that in Mr. Tourette's evidence, he states that he and Mr. Gribby are jointly giving instructions to Jones Day in relation to the fourth defendant's exercise. Now, the defendant's position that there's nothing wrong with Mr. Gribby providing instructions to Jones Day in relation to the disclosure exercise, because that's what Mr. Tourette says. As we state in our skeleton, Jones Day is a reputable law firm. Its lawyers have considerable experience supervising disclosure exercises. They're officers of the court and they're bound by professional obligations. So in those circumstances, we say there's no basis for alleging that Mr. Gribby would do anything improper. But even if he did, which we strongly denied, the fact of the matter is that Jones Day simply would not act on those instructions due to their, among other things, professional obligations. And finally, and perhaps the most telling point from my learned friend Skeleton, is what it does not say on this point. Now, he said it in oral submissions, but he didn't stop to labour the point. Jones Day have confirmed on several occasions that it is they, and by implication, not Mr. Gribby, who are giving instructions to the individual defendants and the fourth and fifth defendants' custodians regarding the disclosure process. Would your lordship please turn up 3582? This is paragraph 1.7 at the bottom of the page. As regards paragraphs 19 to 22, as you are aware, we have addressed your client's allegations concerning Mr. Gribby at length in previous correspondence. Next line, the position has not changed and is not repeated here, except to reiterate that Jones Day is giving instructions to the individual defendants and the fourth and fifth defendants' custodians regarding the disclosure of documents. So in summary, my primary submission, Jones Day are running the disclosure exercise. So in any event, it's being appropriately conducted, regardless of the involvement of any of the defendant's employees, including Mr. Gribby. There's no proper basis to infer that Mr. Gribby is interfering in the disclosure process. It's just an assumption and speculation that my learned friend is making. He's making it off allegations, not on proven facts. However, if they do want to pursue that allegation, if in their heart of hearts that they want to pursue it, they should go away, think of another basis upon which to put it, make the application with the attendant cost risks, and we'll deal with it.
A few short
You want to
points.
say, Mr. Sapson?
Yes, thank you. So the first point is that my learned friend said that RDC 28.14 is concerned with difficulties in relation to the preservation of documents. Well, quite so, and we'd say that that covers the destruction of documents or the loss of documents. So we say that we are squarely within RDC 28.14, and the English case law is really just an illumination of that principle. The second point is that my learned friend made the point that our case is circular because we rely on the allegation of the scheme. And my learned friend didn't appear at the strikeout application, but we had 2 days on this, and the application failed. One of the points that was being run was that the case was in some way circular, but we made the point that there was evidence which showed the existence of the scheme, and in fact I've shown you some more evidence of that today in connection with Mr. Gribby. And so in fact there is a real prospect of success on the case. We say that it's not circular because it's grounded in the facts, and it's actually my learned friend's position that is circular because he is assuming the truth of the defence in order to say that Mr. Gribby didn't seek to alter the record at the time. Now, in relation to how it's relevant to now, well, we've looked at the EY letter, and my learned friend's now telling us that that's not relevant. I mean, I don't quite understand how EY could have got the impression that they should address the letter to Mr. Gribby if they hadn't dealt with him. But in any event, if we go to 511 in the bundle, this is Mr. Tourette's witness statement, and at paragraph 65, Mr. Tourette explains that he is giving instructions with Mr. Gribby in respect of the disclosure exercise. And so the wider point that I made to Your Honour earlier was that, as with Mr. Astruc, he's not independent and he should not be supervising the disclosure exercise. Now, obviously, Mr. Astruc is a party, so he has to give instructions to Jones Day in respect of his own position. and Your Honour made that distinction in the guidance that Your Honour gave before, and we've looked at that. But Mr. Gribby isn't a party. He will be a witness, or he ought to be a witness, we say. He's not independent of the events that are subject to the claim, and so we say he ought not to be involved. And it's James Day's own letter that has raised the spectre of Mr. Gribby having contact with the custodians. Now, it's not a criticism of James Day; it's a criticism of Mr. Gribby, I'm afraid. So, if he's up to something that James Day don't know about, although they've alluded to the possibility that he is having contact with custodians, and given that he has responsibility with Mr. Tourette for the exercise, and that does seem likely, they may not know. They may not be aware that he's having particular conversations. We think that's enough for Your Honour to require him to explain whether or not these sorts of conversations are going on, given the past events that we've looked at today.
The claimants seek orders in the form of paragraph 7 and 8 of the draft order attached to their skeleton. One of those orders is against Mr. Gribby, and the other is against the third defendant, Mr. Carson. Both are accused of dishonesty in one way or another in the particulars of claim that have been served. It is clear to me that so far as Mr. Gribby is concerned, he should not be involved in the disclosure exercise in terms of giving instructions as to what should and should not be the subject of disclosure. It is clear to me that he should not be involved in any way in contacting others who are being asked to give disclosure. In those circumstances, as there is grounds for suspicion that he might have been so involved, it is necessary for the court to take some action to ensure the integrity of disclosure. I have no doubts at all about the court's jurisdiction to deal with matters of this kind. This is a case where fraud is alleged and where the court has ordered disclosure in accordance with CPR 31 of the English court rules, with all the attendant obligations of the parties to disclose everything that might undermine their case or advance the case of the other party. In circumstances of this kind, the court must be in a position to police disclosure and to take such action as is necessary to ensure that it is properly carried out and not in any way tainted by a misdoing of any kind. In those circumstances, both under the terms of RDC 28.14 and as part of its inherent jurisdiction, this court can make an order of the kind sought against Mr. Gribby, and in this case thinks that it is appropriate to do so. The form of the order is unobjectionable in the light of what I have said, and I therefore make an order in the terms of paragraph 8 of the draft order. The position with the third defendant is somewhat different, but he is, of course, the third defendant who is alleged to have been involved in this conspiracy and indeed to play a crucial part in providing information to Mr. Sassoon, which then is utilized elsewhere. The question arises as to whether his own email account has in any way been subject to the destruction of documents. As matters currently appear, there is a letter from Jones Day which sets out the position that Jones Day says obtains in relation to Mr. Carson's practices in relation to deletion of emails sent from or received to his personal Gmail account relating to the business and clients of the first claimant, the fourth defendant, and the fifth defendant. The request that is made, or the draft order that is sought, is for Mr. Carson to file and serve a witness statement setting out whether he has deleted any emails in that context, as opposed to what his general practice was. There is, on the evidence before this court, no basis for considering that there has been any deliberate deletion of emails of any kind. There is no basis on the evidence for thinking that the practice referred to in Jones Day's letter is wrongly stated, though the example given of a particular email that has been disclosed does not, in truth, advance matters at all. The question is, therefore, whether or not the court should, in exercise of the same jurisdiction to which I've already referred, require him to serve a witness statement in which he effectively verifies the disclosure that he has given by allowing Ernst EY to capture the data in his personal Gmail account for the purposes of disclosure. That apparently took place on the 4th of November. The potential difficulty which arises is that no document preservation notice was sent to the third defendant, and the claimants are deeply suspicious about all those who are involved in the alleged conspiracy. In those circumstances, although there is no evidential basis for any suggestion that material may have been deleted, it appears to me appropriate that Mr. Carton, as an individual, should verify the position in stating whatever he can say about the preservation of documents in his email account. Of course, he may not be able to say anything more than what his practice was, because he may have no recollection at all of the details of emails sent and received. But in the circumstances, I think it appropriate to make an order that he answer the two questions raised by the claimant's lawyer's letter of the 7th of October, which have been answered by Jones Day's letter of the 17th of October 2024, and to the best of recollection state whether he has or has not deleted any emails sent from or received to his personal Gmail account relating to the business and clients of the first claimant, the fourth defendant, and the fifth defendant. As to the timing of both of those witness statements, I turn to Mr. Conte to ask for an appropriate time by which that be done.
I'm told that Mr. Carton is travelling, and my instructions are to ask for 2 weeks if we could have it for them to file these statements. Which my submission is they're not urgent. It's not something that the clients need tomorrow.
Agreed. 14 days for each.
Thank
you. What else remains to be dealt with?
There's only one issue left, and I think it's mine. And I would hope that this won't take long, because my learned friend made the mirror submission about an hour ago, and it's about the agreed list of issues.
Oh, yes.
My learned friend made a submission along the lines of the defendants have agreed to provide this many, many times, but then not provided it. We've had enough and have to draw a line in the sand. That's essentially my submission about the draft agreed list of issues. The defendants have agreed to provide it about 3 or 4 times. It's now been outstanding for months. The latest on this is in the letter that was received very late yesterday. There's one line in that letter where they agreed to provide the list of issues following the hearing of the 6th of November. They don't set a date. They haven't signed up to providing it. We're at a point now where it is a very long time after the first CMC, and they have agreed to provide it. I think it's 3 or 4 occasions. I could be wrong about that. There's absolutely no reason not to give the comment. So we would suggest that there's an order that, we say it's fine to provide it within a week. If they can provide it sooner than a week, then they should. But there's absolutely no reason why they should need more than a week. And my submission is that unless they are encouraged to provide it, we'll probably receive another letter that says, we will give it to you, we're coming back to you, and we may never see it for some time.
There's no urgency about it, but you need a date in order to ensure that it happens. That's basically what you're saying.
Essentially, I mean, it would be helpful. I mean, one of the issues ventilated in the disclosure meetings was about one way to limit the keywords. And I take my learned friend's point. He says, well, it's a list of issues. It's not a list of issues for disclosure. But one way you can do it is you can say, here's why these words are relevant, because they go to this issue. And my learned friend says, no, you've got to take that from the pleadings. But the pleadings are quite long and detailed. If you have a more compact list of agreed issues, it would facilitate discussion in the upcoming meetings. And so, although my learned friend takes a technical point, I think they would be quite a useful device to assist the discussions. But at the very least, I think we need a date to encourage the claimants to make good on their word.
Yes. Mr. Sampson?
Thank you, Your Honour. Yes, I mean, I think the list is now sort of over 30 pages long with the comments that we received. Your Honour described it as a non-urgent item, so on the same basis that the witness statements that you've just ordered are non-urgent, could we say 14 days for that?
Yes, I'm content with 14 days. At the end of the day, of course, the list will no doubt, I haven't looked at it, but no doubt begins with the word, there's nothing in this restricts in any way what's been pleaded, or words to that effect. So the pleadings are there, but it is a useful document to have and a useful aid for any disclosure discussions that may take place. I'm going to say actually 10 days. It seems to me that would make sense in the overall context of what has yet to happen for disclosure purposes.
Thank you, my lord. Can I just raise one point that I don't think we clarified? When I was going through my general points in relation to the order, one of the points I raised was for the inclusion of the words insofar as it is available, just to make it very clear that some historic documents might not be picked up. I understood that to be agreed by my learned friend, but I just would like confirmation of that so we're clear in the drafting.
Just remind me which paragraph that would be referable to.
Bear with me one moment. Sorry, my lord. Uh, 4 and 5 were the paragraphs.
I thought it was a specific paragraph in one of those. I
thought it was generally, but bear with me and let me see. I'll take some instructions. It's more generally just as a qualifier to 4 and 5. I mean, ultimately, it doesn't prejudice my learned friend or my learned friend's clients, because if it's not available, we can't produce it and we wouldn't produce it. It's just for clarification and comfort that when we're producing it, essentially, that's one of the grounds that if we haven't got it, essentially, we won't hand it over.
Your Honour, I don't think we need this. I mean, if it's not available, then they'll just say it's not available. They don't have it. And I'm not quite sure. I mean, paragraphs 4 and 5 are going to be reorganised because of the way that your orders have fallen.
No,
But I don't really.
I agree, Mr. Sampson. I don't think it's necessary. If the material or information isn't available, then they will just say so. It's as simple as that. Yeah. All right. Now, the real question now is who's going to draw up the order, and what I don't want is to have a long debate about its terms. So I'm rather hoping, Mr. Sampson, that you will produce a draft to Mr. Conte this afternoon, and that you can agree that tonight, so that I can approve it.
So sorry, my lord, one other point. You said 10 days for the list of issues, but that ends up being a Saturday, and I'm not sure what my learned friend is doing on the Saturday. So perhaps we make it 9 and make it the Friday.
Friday night, 6 p.m. London time.
Works for me. We can even put the time in, my lord. I always like very precise drafting, so that works for me.
Well, it means there can be no dispute then. What I would like, as I say, is for Mr. Sampson to produce his draft. I have notes, but not. But I hope you all have detailed notes of what I've ordered, and that there is limited room for disagreement. In the past, I've discovered, in this case in particular, it's taken a week or 2 weeks for an order to come forward in any sort of agreed form, and then usually with some differences that I have to resolve. I can't really think that ought to arise today. Do either of you see any difficulties at present that I need to resolve now in relation to the form of the draft?
I think Mr. Conte and I will be able to agree. But may I ask, your one drafting point, which is that Your Honour has given guidance that the claimants can use their proposed search terms for their own searches.
Yes.
In my submission, that ought to be reflected in the order.
Yes.
So we had paragraph 3 previously. That will need to be amended to reflect what Your Honour has ordered. But
Yes.
I'm envisaging that we will have something along the lines that the claimants have permission to use the proposed keywords in respect of their own custodians for searches of the electronic documents, and then those will be scheduled to the order.
Yes, but it would also say subject to the defendants being able to put forward in their response of the 11th of November any counter proposals they may have in relation to the ambit of the searches which should be carried out. So it needs to be expressly subject to that, and then of course otherwise the orders that I've made about the timetabling will pick up on both that element and the disclosure to be given by the defendants.
I'm very grateful, Your Honour. That I think helps us a great deal. And then the only other point is costs in the case, I think, at the end.
I think it'll have to be costs in the case, yes.
One other point, my lord, I think you mentioned we will process this as fast as humanly possible. What I'm told, I may not be able to get instructions to settle on the form today. So if it comes to you tomorrow, would that be the end of the world?
That wouldn't be the end of the world, no. I'm just anxious that we shouldn't find ourselves 2 weeks down the line, by which time I will have forgotten everything and unable to decipher my manuscript notes. So
I would be in the same position, my lord. So I'm not interested in waiting for 2 weeks either. So we will push it as quickly as we can, but it may be tomorrow. Is the take
sure.
home.
That's fine. That's fine. All right. Anything else then? Will that do for one day?
I think that will do for today. We are very grateful to Your Honour and to the court staff and to the transcribers for the patience and indulgence that has been afforded to the parties today.
Yes. Oh, there is just one other matter then that we do need to which will have to go into the order too, which is the question of the 27th and 28th of November. What I'm suggesting is that we put those in on a provisional basis in the order, so it's quite plain that's what we're going to do, and that there's then confirmation forthcoming from the court as to those dates. I say at present it depends on my availability.
Sorry, my lord, there's one other point, and sorry for there to be one other very small footnote, but I'm told by my instructors that in order to fully comprehend my learned friend's new proposals, they are going to need the comparison document that they requested via email, and that his instructors said that they would send over. I'm not sure we need a paragraph of the order, but we just do need that as soon as possible, because that will slow down our interpretation of the order. So if my learned friend could give about when that will be sent, that would be very, very helpful.
Do you have one on the drawing board, Mr. Sampson?
I believe HFW are looking at what they can do. I mean, it's not as simple as just generating a red line, because the two documents have a different shape to them, and so you can't just press compare in Word and produce a red line. So I don't have instructions on where they've got to, but I know that they were looking at producing something for Jones Day. I can only sort of offer up a goodwill indication that we've heard what they said.
Best endeavours to produce a comparison by close of business on Friday.
So that you'd like that in the order, Your Honour?
Yes, please. Yeah, on a best endeavours basis. Yeah.
I'm grateful. And then there's only one other point arising out of what Your Honour just said. I think the provisional dates for the hearing were the 26th and the 27th.
Oh, you're quite right. I just said 27th and 28th, didn't I? But 26th, 27th, which days of the week are they? Is that Tuesday and Wednesday?
Yes.
Yeah. Okay. I haven't checked with the court, but as this is going to be an online hearing, I can't imagine that's a problem of any kind.
And they're both full days, my lord?
Well, I much as I dislike starting at 8 a.m. in the morning London time, I fear it's unavoidable, and we'll work on the basis of going a bit shorter than we have today.
I'm grateful, my lord.
All right. And I say I really want to iron everything out that can possibly be ironed out, which is why I'm saying 2 days. Hopefully we won't need that at all. Hopefully you'll all reach agreement and we won't need anything, but I have my doubts. All right, well, I'm very grateful to you both for all your assistance, and very grateful indeed to the court staff for staying so late, and apologies to both them and the transcriber for keeping them from otherwise more exciting activities. If everybody would not mind, can they please sign out and let me have a word with the court associate? Thank you very much indeed.
Thank you, my lord. I'm grateful.